I would like to mention.
Mate will also. I beg to mention item I have not in the list. Is a file for most on Wednesday, 13th.
Wednesday.
Yes.
Please, Lordship, I mentioned the analogous process for orders for delay is there. Fresh filing. Today is not listed. Day after tomorrow, only for orders for delay.
Lordship, I would like to mention for orders MSc appeal, 3 numbers of MSc appeals on 14th, Lordship.
When?
14th.
14.
My lord, with regard to item number 19, my lord, one analogous IA is also in file, but that has not been tagged with the record, my lord. That can be called for, my lord. Today, item number 19, my lord. Stay application along with the.
Wait, with the Lord. I'm praying for posting of 2 interlocutory applications, my lord, to be posted, my lord, tomorrow, because the main connected CRP is posted tomorrow, my lord. These 2 petitions are relating to, my lord, substitution of legal error and for setting aside of abatement in item number 12 of tomorrow's list, my lord. Item number 12.
Item number?
12 of tomorrow's causes, my lord. So in that case, my lord, petitioner, he passed away.
For that matter is listed.
In this court, my lord, before your lordship.
Okay.
So, my lord,
My lordship, I am petitioner in person. So I have filed one petition for argue as petitioner in person. In court number actually 80 today it was fixed, but court number 8 is not being today. So that's why the matter, as the matter is urgent, so I Item
Here, not here.
so that court is not sitting today.
Tomorrow that court will
Item
be
number
sitting.
4 of court number 8.
Tomorrow.
May appeal, Your. I am paying for listing for motion Miller on Wednesday Miller.
May appeal. Item number 36 of today's list. After filing of the MSc appeal, there is a talk of compromise going on between the parties. Matter has been set.
Number
36
36.
may come after 3 weeks. In the meantime, I will file joint compromise petition
When do you want?
after 3 weeks.
After 3 weeks. Sir,
A Bhattacharya.
A Bhattacharya, learned counsel, applicant, stroke appellant, request for listing the matter after 3 weeks. Thereafter.
May please, Your Lordship. I beg to mention one IA in RSA, Lordship.
Party?
IA in RSA. Lordship, it may come up in the orders column.
Where?
Tomorrow.
Tomorrow.
Please, Lordship, I beg to mention a MSc appeal for listing, Lordship.
Where?
Lordship, it's a long pending matter, Lordship.
Hearing or?
For hearing, Lordship, I'm just pairing a that, Lordship.
Okay. Take it that from.
Obliged, Lordship.
May please, Your Lordship. Lordship, I beg to mention for listing of an RFA matter, Lordship, in the order column. So it is connected to money decree, Lordship, and the execution proceeding is pending the day after tomorrow. So, Lordship, may I listing for tomorrow, Lordship?
Okay.
Lordship, much obliged. Also, I beg to mention for listing item number 26, Lordship. I am for the respondents and we have taken a consent for other side, Lordship.
Item number
26.
of today's list.
Lordship. In this matter, the connected IA, we have already appeared regarding coordination of delay. But here we intend to file the Vakalatnama in the meantime. So, Lordship, kindly 4 weeks timing so that we can file the affidavit also.
You are for the respondent here.
Respondents, all the respondents. The respondent is currently residing at Bangalore, Lordship.
With other side, the matter
4 weeks.
after 4. Any objection?
No. Much obliged.
Please, Your Lordship. Lordship, I beg to mention item number 9, Lordship. I am for the respondent, Lordship. I have already taken the consent of the other side, Lordship. This matter may be passed off for the day, Lordship.
You are for?
I am for the respondent on behalf of Mr. A.K. Gupta, Lordship. He has some personal difficulty today.
So, learned counsel appearing on behalf of Mr. A.K. Gupta, learned consent with consent from the other side, respond after
A week, Lordship.
after.
Maybe.
I beg to mention item 51 of court number 8, my lord. In that case, my lord, interim order is there till today. It may extend.
May I please, your Lordship? Lordship, I beg to mention for listing of RSA, my lord. It's a old matter, my lord, 2018 matter.
Oh, Eric,
Yes, my lord.
when do you want?
On Monday, my lord.
Next month, after 15th of
Any date? 9th. Okay. Obliged.
If I may, my lord, I beg to mention item number 49 and 50 of court number 8, my lord. My lord is
number
for, yes,
when do you want?
Monday, my lord, if possible on Monday.
Next Monday.
Yes, ma'am. Deeply obliged.
May I please, your Lordship? Lordship has earlier admitted an RSA. In that case, Lordship, in the IA, Lordship has issued notice. Now they have already filed the execution case. Problem is that
When
Lordship,
the next set is fixed.
next 28, Lordship. Before that, Lordship, if Wednesday possible. Obliged.
May I please, your Lordship? I am listing a pair for listing of RSI for withdrawal.
When?
Tomorrow. Withdrawal. And another matter for admission, same RSA. 20. Okay.
May I please, your lordship? I beg to mention item number 3 and 8. Your lordship, this matters may be adjourned for the day due to personal difficulty.
You are for?
D. Rathi, your lordship.
You are for?
For the petitioner,
Okay. Miss, your good name, please?
R. Hussain, your lordship.
R?
R. Hussain, your lordship.
R. Hussain, learned counsel. Repeating on behalf of Mr. D. Rathi, learned conducting. You inform the other side
Yes, your lordship.
with consent from the other side as well.
After 2 weeks.
After
May it please, my lord, because I beg to mention an interlocutory application for listing on Tuesday, my lord, next Tuesday, my lord, 19. 19. Deeply obliged.
May I please, your lordship? Oh, item number 23. We want to withdraw the matter.
23.
Mm.
Miss, your good name?
As per on appearing on behalf of PJ Mukherjee.
Yes, for the appearing on behalf of the protecting counsel for the he has the instructor get recording out for petition number 1 of 2025. Yes.
May I please, your lordship? So I beg to mention the listing of an item for withdrawal. It pertains to court number 8, was listed today. It will be listed tomorrow. Tomorrow.
May I please, your lordship? Lordship, I beg to mention for listing, my lord, met appeal, my lord, for judicial separation of the devote petition, my lord.
When?
My lord, it is challenging the earlier order, my lord. Next week, my lord, any date, my lord, long pending case, my lord, 24 matters. No, admission matters, my lord. My lord. The similar matter also another.
My please, Lordship. Item number 20 is listed today, Lordship. 29, sorry. If for order, there is some urgency, Lordship, injunction petition is pending. It may be upgraded, it may be taken just after admission.
Pardon?
Mm.
Oh, we'll take up the matter today.
Your Honor, since last 4 months.
No,
For-
today we will take it up.
Okay.
Yes.
Please, the lordship. Your lordship, I beg to mention 2 RSA for listing in orders column, lordship.
When?
Can it be on Thursday, lordship?
No, next week.
1 RSA, lordship, kindly on Wednesday.
May I pay for listing of an injunction matter, my lord? We have filed an first appeal against the status quo order granted by the learned court on Friday. Can it be taken up, my lord, day after tomorrow, my lord? Can it be listed?
Okay.
Much obliged.
May please, the lordship. Lordship, regular bail application
petitioner behind the bars for 3 years, 9 months, 16 days already.
3 years,
9 months, 16 days.
16. At what stage it is pending now?
It is in the evidence stage. 8 witnesses listed, only 2 examined till date, Lordship.
How many witnesses examined?
2, only 2.
Third is
M. Sultana.
learning for the accused and to hard is
R. Hussain, your lordship.
learning counsel appearing on behalf of the
SCKL.
trial, learning counsel. Learning son of the NP. This application for the authority of the BN 23 is referred by Aselal Sahan, who has been languishing in Jalaluddin NDPS case number 73 of 2020, arising out of NCB crime number 28 of section 8, which is C, stroke 20B, certificate Roman, C, stroke 29 of the NDPS. Pending the number 5, was it up 25/10/2021. This is second or third bail application.
Second, Lordship. This is the second one.
External learned for the means that the second bail application for the when the first one was dismissed by this court, being BA number
2562, Lordship.
56/24 by order dated 21/10/2024. At this second bail application is deferred on the ground of
Co-accused has been released on bail on similar ground.
ground of variety. As one of the co-accused, namely
Pappu Kumar Sahani. Pappu Kumar Sahani.
Kumar Sahani,
And it has been annexed
enlarged by which court?
Lordship P.J. Suike. Honorable Justice P.J. Suike.
By coordinate bench of this court. Do you have the number?
DA number 3901, Lordship, page number
DA
84.
number
3901. Page number 84, it has been annexed.
number 3901 of 2024 by order dated 18/6/2025. The further submits that the accused is lengthening jail for more than 3 years, 9 months, 16 days, and the prosecution side has examined lead witness still there. The submission of the further call for the scan copy of the record from the trial court, fixing the matter on
Lordship, can it be after 22nd?
27.
27. After 22nd, Lord.
like
Lordship states has been taken off.
the matter is listed for
Admission, yes, Lord. The CRP is filed against the order of the Munsi Court, Kamrup, Lord.
where is the impugn order?
Annexer. Page number 115, Lord.
115, please.
Yes. Yes, argue.
No,
Are you ready to argue now?
no, Lord.
Why? Who will argue the matter? You or by your
My senior Lord,
who is your senior?
Mr. M. Sharma.
M. Sharma is absent today.
He is legs before another court, Lord.
So today agenda matter for
Yes,
today.
Lord. Yes, Lord, for today.
The appeared made by Miss
Yes, Yasmin.
for the alternate counsel appearing on behalf of Mr. M. Sharma.
M. Sharma.
Adjourned for the day.
Much obliged, Lord.
May I please, Your Lordship?
Yes. Go
For the petitioner,
who is for the respondent?
maybe absent here.
Don't know. Is he present today?
I am appearing for three, Lordship.
Respondent.
Yes. Only respondent number one, only sole respondent. The copy of the petition is not provided. Let them serve it.
When you have filed Ukalatama?
Lordship,
When you have filed Ukalatama here?
forget the date, but in last occasion, Lordship, they have not appeared and therefore.
Okay. Heard, Mr.
A. Muhammad.
Learned counsel for the Mr. Dr. Salim said he has not been part a copy of the petition. And as such, he is not ready to argue the matter. The learned counsel for the petitioner said he will furnish a copy of the petition. So during the course of the hearing, furnish a copy to him. The matter. When do we want Mr. Dr.
Any day after 15,
After but
27. Obliged.
That is Your Lordship. My Lord, this is regarding an uncontested, unprivileged probate proceeding, whereby the learned trial court has dismissed the probate proceeding only because the attesting witness, one of the attesting witness, he has not
no,
been.
no, you are not a contesting party before
No,
the
no
trial.
one has been contesting. And the only, this isn't in probably is a fault of the on the part of the council, because the petitioner has submitted his examination.
But ex parte judgment was passed.
Judgment was passed dismissing the probate proceeding only on the ground that the one of the attesting witness who has given a declaration in the probate proceeding, he has not been examined. Only for the ground. My Lordship will find page 34. The order. It's basically a mercy-based petition, because only the attesting witness has given the declaration also. The declaration, Your Lordship will find at page. Everything was in order, but only since it was not contested, the petitioner has given his examination in chief, but
You were the petitioner in the trial court.
Trial court.
Okay.
Nobody has contested.
Yes.
All are.
Notice was served.
Notice was served, and the petitioner has also, it was proceeding ex parte. So petitioner is given the examination in chief, but the person who has given the who was attesting witness, he has not given the examination in chief, although he has given the declaration as required under the law, along with the probate application for probate.
but it was inadvertently not given, and for this reason, this probate was not granted. Your lordship will see page 34, last paragraph. Everything was in order. Because as per 68 of the Evidence Act, this is the mandate, at least one attesting witness has to give evidence. That was not given. And he is well there. He is there. He will give, and any day, if your lordship permits, and on any day he will give evidence. Kindly see page 34, last paragraph. As per section 68 of the Indian Evidence Act 1872, a will must be proved by examining at least one attesting witness unless such witness is dead or cannot be found. In this case, although the name of an attesting witness, Ramesh Theory, OP2, is mentioned in the petition, he is not examined by the petitioner. In absence of such examination, the execution of the will cannot be held proved. In view of the above, petition grant for a probate is hereby dismissed on the ground of failure to prove the execution of the will and accordance with law, particularly for not examining any attesting witness. Now, your lordship will kindly see first page of the order, page 33.
Is 30?
Page 33. The first page of the order. This OP number 2 is the attesting witness. Page 33. Last paragraph. The death of the testator and execution of the will has been supported by an affidavit of one attesting witness, namely Ramesh Tiwari, OP number 2. The petitioner has also submitted an affidavit of valuation of estate and deposed that no other application for probate has been filed in any other court. So OP number 2, who was the attesting witness, he also filed a declaration to that effect along with the probate application for probate. That was also there. But since at the time of evidence, it was not given, his examination was not given as per the mandate of section 68 of the Evidence Act, this probate proceeding was dismissed. But, may I pray only one chance may be given to the petitioner, otherwise his uncle is there. He can give evidence.
OP number 2.
OP number 2. They have never objected. And in fact, page 16 is the declaration of the OP number 2.
In your petition, the memo of appeal, where you have mentioned that ground.
My lord, ground number 2. And ground number 7, an opportunity should have been given to him. The learned trial court should have given one chance to the petitioner.
Take the third date or not the appellate. Take the 99 order five is probate case for 60 20 order date signal after has the application filed by the petitioner filed by the appellate regarding grant of probate on the ground of failure to the particularly not where is your application?
The application starts from page 8, my lord. And the declaration of the OP number 2 is page 16.
No, whether such a declaration is provided in the act.
Yes, my lord. Along with an application under 276, a declaration of at least one witness has to be given. That is
Then
given.
why he has not been cited?
It was inadvertently because of it was proceeded ex parte, so they thought perhaps it is not required. But it is the mandate of law under section 16. At least one attesting witness should give his evidence. An opportunity may be given. my lord.
The appellant submits that the appellant hearing filed on probate case, the probate case number of 2020, who grant of probate of unprevailing with in respect of last will and testament dated 5/20,002 by the grandfather of the petitioner suffered demise on 18/3/2002. After the demise of the testator, the appellant hearing filed the probate case for execution of the will supported by an affidavit of attesting who has been arraigned as opposite party for the or further that though the will though the opposite party the state probate case has not contested the case, there was no suspicious circumstance surrounding the act, but the current speaker has it clearly on the ground that the attesting witness was not and that the state attesting witness was arraigned as OP number the probate proceeding, and he is ready to produce evidence and as such, Mr. Toro submitted an opportunity granted to the petitioner to the appellant here examine the OP number 2 as attesting the to the court of learned district. Having heard the subject of the appellant it appears that in the said order, the learned district judge observed that section 68 of the Indian Evidence Act 1872 provides that a will must be proved by examining at least one attesting unless such dead or cannot be found. When in the extent case, although the name of the attesting has dropped to the cricket compass or of open part 2 is mentioned in the petition, he was not examined by the petition and absence of such examination cannot be held. Taking to the submission of the court for the that has to be given to the appellant as of it is under such allow this appeal that is on this side itself. The keep order date, then the consequence, the learned listing the asserts so directed to afford an opportunity to the appellate hearing, examine the OP number and thereafter hear the matter evidence, dispose of the same transfer of this testamentary appeal.
Obligement.
Target for the for the appellate one.
It is lordship, my lord. The land acquisition appeal, there were in fact 10 appeals, my lord. 8 have been admitted. And on the, my lord, your lordship was pleased to admit one appeal and also was pleased to pass the interim order in the order 14 rule 5. The lordship will pass the same order because same award, my lord, by 10 different persons in reference. Same award, my lord. Lordship was already admitted 8 have been admitted already. Same order may be passed. Deep blue.
So it take all these matters together.
Yes, my lord. In fact, there is one more that we admitted, then Lord will
After there.
learn.
Also, this is regular first appeal against the impugn order dated 3rd June 2025 at page number 9, Lord.
Third means
S to the Lord.
learn it for the appellate. This regular first appeal is directed Article under section 6. Judgment and decree dated 6/2025 passed by the learned chief judge in title number 13 passed by the learned title number 13 whereby the learned civil judge in your has dismissed the title 13 peruse the memo of appeal and ground for that and also peruse the judgment and decree dated admit
Okay.
that not the return the alien process. That's it. All for the court below. Please the drafted for each.
Obliged.
Regular.
Heard to be by the learned court of appeal with the message of the Code of Civil Procedure directed the judgment and decree dated 31/25 passed by the learned civil judge for one company was entitled to number 30. It is to be noted here that high judgment is related to the learned trial court that decreed the part of the memo that appears down to part of the by admit notice to the let's call for the court high part of the instruction. In I let notice go at this
Notice go. Okay. My please, Lordship. This is a appeal against resident in decree passed by the learned civil judge, which are in title suit number 42/2021, and thereby passing a preliminary decree. This is a partition suit, Lordship. The first appeal.
further as they progress so learned for the appellate. Six appeal under section 9 the Code of Civil Procedure directed against the judgment and dictated by section 5. And second preliminary decree signed 24/6/2025 passed by the learned civil judge exception number 2 Kasar Chichor entitled for declared by the judge court below has decreed the thereby passed the bill in the memo of appeal
Lordship.
Judge
Page 6.
12/5 admit notice to the respondent the BT register call for the record from the learned court. This is the I
is the for stay of the stay operation of the, because it is a preliminary decree. If final decree process is completed, then there will be problem.
let not
Because Lordship, in a partition suit, it is sent to this collector. So it has been ordered, the preliminary decree is passed, and it has been sent to the collector for rest of the part. Then final decree will be put up. So if it is completed, then purpose of preliminary this appeal will be in respected.
it's appeal under order interpreted application 5 of the Code of Civil Procedure application of staying operation of by the learned civil judge in number 21 whereby the learned trial court has decreed the outcome within its certificates of success appeal as already admitted by this court and notice record as also and that there is a requirement of stake operation of the judgment. Yes. In the event of sending the judgment the collector, filter, and if the person affected by the collector person to the city, then the present appeal becomes person as far as state the operation of the bill disposal of cost of the connected cost. Whereas if the each of opposite part. The bit area also by the taking to the top just to learn it happy. So what is 40 of the best. There is a requirement of state for well, the event of effective parties. The method of recording the judgment and state still return a
Much obliged.
Is an appeal against the judgment dated 28/2024. Wherein
or dismiss.
Lordship, what has happened in the I was not made a party in the main suit. Thereafter, while I was going to pay the revenue, I got to know that a suit is pending. Thereafter, I filed an application under Order 21, Rule 97. That thing was registered as this Miss J case number 113. Thus, my specific averment was there that the present decree holder was a party to the original sale agreement. He was a witness in the original sale, which was taken from his father. But suppressing that fact, Lordship, he had obtained a decree, and that issue was not framed. Whether it was obtained by suppression of material fact and by fraud, that issue was not framed, Lord.
No, if you have filed an application under order 21 rule 97.
97.
What order was passed by the executing court?
Sorry.
What order was passed by the executing court?
Lordship, this is the order in Miss J case that is under appeal.
Your petition was dismissed.
Yeah, my petition was dismissed.
On what ground?
I could not prove my right title interest. It was treated as a separate suit. But the material point was that the main issue that he was a witness to the original sale, that thing was suppressed, and he admits in his cross-examination that yes, this is my signature, Lordship, at page 103 and 108.
No, in the application order 7.
Yes.
What do you have 7?
Lordship,
what was your prayer?
Because we were the interested party, therefore we should have been made a party. Now also we are in possession of the land. Therefore, without making us a party, they have obtained a decree.
Order Appellate appeal under direct against the judgment dated 28/8/2024 passed by the learned executing court in case number 113 of 80 arise out of the for corresponding to title part of filed by the personal memo of evidence of order order dated 28 4. Admit its knowledge for area. Call for the record the verdict. Court will listen. Where is I?
Hey, look.
Hello, what is this? The
Okay, we-
execution proceeding pending now.
Yes, that notice, Lordship, we have not received. So therefore now, Lordship may give a notice in the IA, but we have not received anything from the executing court, Lordship. Regarding,
After passing of that impugn order.
yes, after passing of the impugn.
Deeply. Deeply obliged.
May please, your lordship. This is statutory appeal, your lordship, against the suit for recovery of damages on account of defamation and malicious prosecution.
What happened? What was the dismissed?
No, I was the defendant. Suit was decreed, your lordship.
Decree?
Yes, lord.
You are the
I'm the defendant appellant.
officer here. It's appeal under order for judgment dated 3/25, 5.
Lordship. Suit for it was a suit for recovery of damages on account of lordship defamation. Registered as money shot, your lordship.
For the record, what below? Yeah, that notice to it.
Lordship. Oblige, your lord.
May I please, your lordship, please take up this matter after some time. My senior is on it.
Made clear.
Yes.
Well, this was against the judgment passed by the tribunal. Against the order passed by the Rera authority. Which one here, Malad? Whether the Rera tribunal can pass a judgment sitting singly. In the earlier occasion, my learned friend submitted certain decisions of the Apex Court as well as the coordinate bench of this court. But in this coordinate bench, my lord, held that the authority of a single member of authority is permissible. When, my lord, when there is a written order in terms of section 85, in the Rera authority, not tribunal, my lord, we are against the authority, tribunal, my lord. Tribunal can pass a judgment sitting singly in terms of the order 85 if there is a written delegatory power. Otherwise, the Rera authority is formation under section 10 of regulation.
Appellate.
No, tribe authority, yes. 10-1, 21, my lord.
21 of the appellate, 20 of the authority, RERA authority, formation of RERA authority, section 20, my lord. Establishment and incorporation of real estate authority, section 20, page 27, my lord, section 21, 20.
Yes.
The appropriate government shall, within a period of 1 year from the date of coming into force of this act, by notification, establishment authority to be known as the real estate regulatory authority, to exercise the power conferred on it and to perform the function assigned to it under this act, provided that the appropriate government of 2 or more states or union territories may, it deem fit, establish one single authority. But composition of the authority at page 28, section 21. The authority shall consist of chairperson and not less than 2 or whole-time member to be appointed by the appropriate government.
Which section you are referring to?
21, my lord. This is the composition of the authority.
Chairperson not less than member.
Yes. Already the definition of the authority and, my lord, the tribunal is at section 2F. 2F of the, my lord, appellate tribunal, and 2G1, 2H1, my lord. Page 2 of the act. Section 2H1. Section 2H1 is the authority.
The coordinate bench of this court deals with section 2H1.
1, my lord. In 1, single member of the authority can pass a judgment.
Okay.
Where
Not
there
in
is a,
case of appellate.
yes, where there is a specific written order, which is section 85 says. All right, I am going to 85, my lord. 81, not 85, sorry, 81. Delegation. 81, my lord, page 54. The authority may, by general or special order in writings, delegate to any member, officer of
section
81, my lord. This is delegation.
Yes.
The authority may, by general or special order in writing, delegate to any member, officer of the authority, or any other person subject to such condition, if any, as may be specified in such order, such of which power and function under this act, except the power to make regulation under section 85. But here is the authority, and formation of the authority is different, and formation of the tribunal is different. Mal. Tribunal is composition as per section 43 of the act. Composition of appellate tribunal, and the definition of 2F, my lord. Kindly see, my lord, first the definition of appellate tribunal. Appellate tribunal means the real state appellate tribunal established under section 43. Not I am 43, my lord. Application for settlement of dispute and appeals to appellate tribunal, my lord. This is 44. And 43 is, my lord, establishment of real state appellate tribunal. 43.3, my lord, can you see?
At least one judicial member and one administrative or technical.
Yes, my lord, 43 subsection 3, my lord. But the Supreme Court, as well as our coordinate bench, my lord, hold that the authority can pass a judgment sitting singly, my lord, not the tribunal, my lord. They are not challenge the tribunal order, my lord. We are in tribunal, my lord. Whether the tribunal can function sitting as a single member of the tribunal. In that case, my lord, the apex court not pass any order, my lord. Can you see what is the apex court says in my lord, paragraph 119? In view of the remedial mechanism provided under the schemes of 2016 Act, in our considered view, the power delegation under Section 81 of the Act by the authority to one of its members for deciding applications complaint under Section 31 my lord, of the Act, it is not only well defined but expressly permissible, and that can be said to be the divorce of the mandate of law. But that is the dictum of law, my lord.
Which paragraph in our date?
119 of the my lord, this is judgment, my lord. It was a case of my lord, new tech promoters and developers. It was passed by the apex court in 2000.
Which paragraph you were reading?
Reading, my lord, 119, my lord. It was record, my lord. It was on record, my lord.
The judgment is there, your lordship. New
Yes, my lord, that is why.
Yeah,
I got
line
119,
2021.
Yes.
It
The
was in
scheme of act.
Yes, my lord. Here, my lord, can you see? The single member of the authority is permissible. Can you see paragraph, my lord, 112 and 1111, my lord. May I read, my lord, 111, my lord, 111. Section 81 of the Act, it empowers the authority by general or special order in writing to delegate, my lord, I have already read it. Paragraph 112, in the instance case, the authority by a special order 5/12/2018 has delegated each power to a single member for disposal of the complaints filed under Section 31 of the Act. This is the matter delegatory order. My lord. There is a specific order on 5/12/18, my lord. That is why the Honorable Apex Court says that the single member of the authority is permissible. My lord.
Yeah, so
Lordship, in this regard, I would like to draw your lordship attention to section 55 of the RERA 2016, your lordship.
section 50.
55. Lordship, vacancies, etc., not to invalidate proceeding of appellate tribunal. No act or proceeding of the appellate tribunal shall be invalid merely by reason of any vacancy in or any defect in the constitution of the appellate tribunal or any defect in the appointment of a person acting as a member of the appellate tribunal or any irregularity in the procedure of the appellate tribunal not affecting the merit of the case. It is a specific power has been given, your lordship. Statutory law is there that any vacancy, any defect in constitution constituting the benches, your lordship, that will not invalidate the judgment or order proceeding, your lordship. It is for the appellate tribunal, your lordship. And in respect of the authority, in section 16, it is defined, your lordship. Section 30. Vacancies, etc., not to invalidate proceeding of authority. No act or proceeding of the authority shall be invalid merely by reason of any vacancy in or any defect in the constitution of the authority. The law itself says, your lordship. And there is no contradiction in passing the judgment.
I think it's cause B and cause B will help him. Because, there is a limit that irregularity in the proceeding.
Yes.
No, clause A, your lordship, any vacancy in clause A. My submission will cover by clause A, section 55.
Regarding the composition of the tribunal.
Composition of 45.
45.
Yes, 45.
Chairman and not less than
Yes, your lordship, composition of appellate tribunal. The appellate tribunal shall consist of a chairperson and not less than 2 whole-time members, of which one shall be a judicial member and other shall be a technical or administrative member to be appointed by the appropriate government. This is section 45 is there, lordship, but specifically in section 55, your lordship.
So, should we ignore this provision of section of 45?
No, lordship.
Then
we will not ignore.
Then
there is provision that the composition of appellate tribunal shall consist of a chairperson and not less than 2 whole-time members. It ought to be there. But in case, your lordship, if there is any vacancies, so section 55 will power the member or chairperson. By virtue of section 55, your lordship, the existing chairman but chairperson
Section
55, your lordship.
It will not come under, it cannot be, Malad.
Lordship, it is there, your lordship. It is specifically stated, lordship, any vacancy, your lordship. Section 45 says, lordship, for composition, your lordship. There has to be the tribunal shall consist of 1 chairperson and not less than 2 whole-time members. And
Here, Malad, another judgment of the Supreme Court, Malad. Here in this separate case, Malad, here a single member of the Malad bench, he reviewed the order of a full bench judgment. And Supreme Court says a single bench of the member will have to wait for the others. Means, Malad, there may be a vacancy, maybe vacancy, I do not know, Malad, that the appellate tribunal should have, Malad, comply to 45.
As because, lordship, under section 55, your lordship, the appellate tribunal has the authority to pass order if there is any vacancy, your lordship. It says this, your lordship. It is specific clause A will come into play, your lordship.
Other, my lord, whether they have exercised the authority power, my lord, whether any written order or not in the record, my lord. Therefore, the appeal may be admitted at this stage, record may be called for. Everything will come out, my lord. If there is no written order in terms of section 81, then, my lord, authority order will go. So, my humble submission, the substantial questions which I have suggested before your lordship can be framed and the record may be called for, my lord.
As because, lordship, there is a specific provision, your lordship, that if any vacancy is there and any order was passed by not by whole member, that would not invalidate, your lordship. And in respect of authority also, your lordship, section 30. Section 30 is there in respect of authority. No act or proceeding of the authority shall be invalid merely by reason of any vacancy in or any defect in constitution of the authority. And for this part, lordship, so I will convince your lordship for this particular aspect, your lordship.
When?
Lordship, after 15th of August, any date, Your Lordship.
Not tomorrow.
Not tomorrow, Your Lordship.
Supreme Court, matlab,
He wants to go through that next 50.
yes, matlab, but Supreme Court, matlab, this ratio then is matlab, Supreme Court clarify. Matlab, I am saying, matlab, the
No, that cannot help you because the original judgment was passed by his judgment.
yes, but that is required for
By a single judge.
yes.
That is different thing, Your Lordship.
The
Review.
Supreme Court says that since it is 3, so you have to wait for 3. 43, matlab, section 43 says that there should be at least 3 members, matlab. So the appellate tribunal should have to wait for that.
Not 51, this section 55, you go through it. Then.
I'll try to convince in respect of section 30 and 55. 30 and 55, Your Lordship.
Then on 18,
Lord.
18,
19. Lord.
18, Monday. Arthur dictators learned for the appellant. Or please the method on 18. Oh,
Not 18, 19, matlab.
19.
19.
18.
No, Lordship, as Your Lordship phone.
Any inconvenient?
19 is matlab, Tuesday, matlab.
Yeah.
19 is Tuesday.
Then 20, Lordship.
Hearing.
Then 20, Lordship.
20.
Lordship.
Not 20, matlab, 20, I am out of station, matlab, 21.
18, 18?
21, matlab.
18. That would be again hearing day. That would be again hearing day.
Let it be on Monday.
Monday.
Lordship, Lordship. Monday.
Second appeal matter has been filed, challenging the judgment and decree passed in title appeal number 31 of 2016, passed by the learned civil judge Karimganj, reversing the judgment and decree dated 16/8/2016, passed by the learned Munshi number 2 at Karimganj in title suit number 250 of 2007. The original in the original court, my lord, the judgment came in our favor, and the other side went for appeal, and in that appeal, my lord, the learned appellate court below reversed the finding and judgment of the trial court, and it went against us. Accordingly, my lord, challenging this judgment and decree of the lower appellate court, this second appeal is filed, my lord. Now, basically, my lord, we have, my lord, second appeal, my lord, challenging, my lord, that the lower appellate court misread, misconstituted, and justified in setting aside the interpretation of section 68 of the Evidence Act, by which the learned Munshi number 2 Karimganj rejected the sale deed of the respondent plaintiff for his failure to call any of the attesting witnesses to prove the sale deed. On this law, one matter, section, whether this interpretation of the learned appellate court below, interpretation of section 68 of the Evidence Act is correct or not, my lord. And secondly, my lord, whether the, my lord, learned appellate court acted rightly and legally and properly on point number 2 disregarding the denial of the execution of any sale deed by the appellant in respect of the plot number 1 of Schedule 1, more particularly described in Schedule 2 in favor of plaintiff. And thirdly, my lord, whether the Lord Appellate Court failed to exercise jurisdiction under Order 14, Rule 1 CPC of 1908 while dealing with the issues claimed on the suit.
Moreover, my lord, whether the Lord Appellate Court was right in and proper in disbelieving the sale deed created by the appellants, particularly mentioned in Schedule 3 of the plaint in the year 2007, and declaring the same sale deed as void and illegal under Section 7 of Transfer of Property Act. Whether this interpretation of the Lord Appellate Court, interpretation of Section 7 of the Transfer of Property Act is correct or not. Moreover, my lord, whether the findings of the Lord Appellate Court are hit by Section 5 of the Transfer of Property Act. So your lordship will see, Lord, 8 of the Evidence Act. Section 68, my lord. Proof of execution of document required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving the execution. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence. But the other side may not fail to.
What is the copy of the plaint?
Not.
It's 39.
What are the pair?
Yes, my lord.
Where's my lord? Page number 46. Declaration that the documents mentioned in Schedule 3 are void ab initio, collusive, fraudulent. Page number 46.
No, I found the pair in the
Plaint. Where's
pair in the pair in the plaint.
page 46? Para 12, A, B, C, D.
But you have referred 37 or the or 30?
Yes, my lord, page number 37. This is the pair of the plaintiff.
Copy given to me has been wrongly paginated, my lord.
Okay.
It is wrongly arranged.
Let him give me a proper copy, my lord. Then page 37 is my copy is having a decree, my lord. Let him furnish a proper copy, my lord. Then the matter may be heard, my lord. Whatever I submit will be in the wrong pages, my lord.
All right, my lord. I'll punish the clerk has wrongly arranged the pages, my lord. I also see. Yeah.
So when can it be?
My lord.
When?
By tomorrow, my lord.
Can we fix on next week, my lord?
Matter may kindly be taken even day after tomorrow.
Yeah.
Or on Friday, my lord, if your lordship kindly permit. Right.
Friday will be 15 August.
After 15th of suggest any date.
Monday next week.
0.
Or you're good. Right?
Yeah, Talukdar.
Here, the
HK Borua, my lord.
HK Photo learned online. copy of the memo of appeal and the documents furnished to him are not properly present. And as the right for directs the appellant or correction copy of the memo of appeal. Here is according to law.
Obliged.
Highly
When,
obliged.
Mr. Talukdar, when we are able to furnish the copy
My lord. By tomorrow.
or
Copy of the IA also may be given to me.
Dr. Samsai, by tomorrow, furnish a copy of the corrected memo of appeal along with the IA.
IA.
Obliged.
Highly obliged.
May it please your lordship. Lord, this is a appeal against the judgment of reversal, my lord. In original case, court, my lord, actually,
Decreed or dismissed. Trial court dismiss or decree.
Trial court dismiss the appeal, allow the counter claim. The first appellate court has allowed the appeal.
his appellant is the defendant in original suit, my lord.
Counterclaim, no appeal was
Only one appeal has been.
Actually, that is the main problem here, my lord. Counterclaim is allowed, suit was dismissed. They filed only one appeal, against which they filed the appeal that is not clear here. The appellate court also decreed the suit, my lord, in one year. But regarding counterclaim, my lord, simply one sentence, the counterclaim is dismissed.
but no appeal was preferred.
Originally, my lord, there should be two appeals because counterclaim is treated as a plaint. That was decreed. Your lordship may be pleased to see last of the judgment of the original court, my lord. At page at page 114, my lord. 114. In view of the foregoing discussions and reasons, the suit of the plaintiff is dismissed so far as specific performance is concerned. But the plaintiff cannot be thrown out from the Assam type house where the defendant acquits the claim of the plaintiff over there, considering the advance to be adjusted as consideration for the same. On the other hand, as prayed, the counterclaim of the defendant is allowed to the extent of removing the plaintiff or man agents from the RCC building described in the schedule of the counterclaim, prepare the decree. Actually, my lord, there is the original oral agreement, my lord. Their prayer is not specific. Your lordship may be pleased to see again the prayer portion of the plaint. At page 13, my lord.
Page 13.
Page 13, my lord. 1-3.
No appeal.
A decree for specific performance of contract against the defendant and in favor of the plaintiff, directing, compelling the defendant to execute a formal deed of agreement. He prayed, my lord, for a formal direction from the court of executing a formal deed of agreement. Then, my lord, in favor of the plaintiff, regarding transfer of the suit land to enable him to obtain the bank loan as arranged by him, and so to execute and submit the required application duly signed by the defendant to Guwahati Municipal Corporation, Guwahati Metropolitan Development Corporation, and Deputy Commissioner Kamrup, Guwahati, to obtain necessary NOC for formal transfer of the suit land and building, and also directing and compelling the defendant and register the sale. This is the prayer, man. It's a very peculiar prayer, my lord, because there was no agreement. Only, my lord, an amount of rupees 2 lakhs was given, that too for a Assam type house. But during the pendency of this, these things, suit, he entered the side building. There is a RCC building of the defendant's father. He entered into that building and he stated that the entire property, land and houses were agreed to give him in specific performance. The learned trial court fully discussed everything and ultimately passed that order, allowing the counterclaim regarding the RCC building, my lord. But it was allowed that they already, as they have already paid rupees 2 lakhs, so they may be allowed to remain in the Assam type house. But they preferred only one appeal, my lord. Against that, my lord, the appellate court, my lord, very strangely, again, I am placing the paper paste, my lord, 114. In view of the foregoing discussions and reasons, the suit of the plaintiff is dismissed so far as specific performances is concerned. But the plaintiff cannot be thrown out from the Assam type house where the defendant acquits the claim of the plaintiff over there, considering the advance to be adjusted as consideration of the same. On the other hand, as prayed, the counterclaim of the defendant is allowed to the extent of removing the plaintiff, her man agents from the RCC building described in the schedule of the counterclaim, prepare the decree. So, but the appellate court, my lord, appellate courts, my lord, page 142, my lord. In only one line, my lord, he set aside. 142, the appeal is allowed. The judgment and order dated 24/6/2015 passed by the learned civil judge number 1 Kamrup Metro in so whereby learned the trial could dismiss the suit of the appellant and allow the counterclaim is hereby set aside. This is the only one line. And hold the plaintiff be able to prove its case as such prayer of the plaintiff is allowed to the specific performance of the contract. The respondent defendant number 1 is directed to execute sale deed in favor of the plaintiff. Earlier conditions were not fulfilled. Here he is prayer to sign an agreement for sale, then file application for NOC, then only the execution of the sale deed. But the learned appellate court allowed all without considering anything, my lord. Because at that time, he stated that I have already applied for a loan and loan was granted, but he has not filed not a single document. That loan was granted to him, but the appellate court was satisfied that a loan was granted. Where is the document? And regarding the, my lord, this, there is a case. Of our High Court, my lord, regarding the 2 appeals. Honorable Justice Suman Sam, my lord, before him this matter came, my lord. Note B, my lord. Common judgment disposing the suit and counterclaim. Suit decreed, but counterclaim rejected. Appeal therefrom. Single appeal preferred against the part of the judgment pertaining concerning suit and not for part concerning counterclaim. Be that it would be open to the appellant to argue on the merit of the counterclaim, even though no an appeal on the finding thereof has not been preferred. That was rejected. Until and unless there is a separate appeal, my lord, it cannot be entered. That argument was rejected. It is at page para 17 and 18, my lord, last.
Right.
Before pertaining with the record, it would be appropriate to mention that by relying upon the provisions of Order 41, Rule 33 of the Code of Civil Procedure, the learned counsel for the appellant has submitted that even though the appellant has not preferred any separate appeal against that part of the judgment and decree whereby the counterclaim to appellant defendant number 3 had been dismissed, yet the appellate court has ample power to entertain any such plea and pass appropriate order in the facts and circumstances of the case. In support of the said argument, the learned counsel for the appellant has relied so and so. Para 18. There can be no doubt that the proposition that in order to complete justice, the appellate court would be ample power to entertain such issues in similar circumstances, even though an appellate has not been filed against such part of the decree. However, having regard to the facts and circumstances of the case as well as the findings recorded there, herein before, this court is not inclined to exercise such discretion and permit the appellant to argue on the merits of the counterclaim at the case. My lord, I have formulated certain.
2009, but
Okay.
it available.
No, not with us. Okay. Your lordship may be pleased to see. I have formulated.
I have seen it. One more case is pending regarding this same subject matter.
Yes. Actually, I have not taken this ground.
Has been adjourned
Hmm.
to satisfy this court that two separate appeal has to be heard.
Now, my lord, as the appellate court has passed the judgment by a single judgment, my lord, I have preferred. And I have given the substantial question of law at page 5, my lord.
I have seen it. But let us see this judgment of Supreme Court. Which this single judge.
There are some other questions also, my lord. There are some other questions. That is only one point, my lord. There is some other question. Your lordship can discuss it very well in the final hearing of the case, my lord.
That's all right. But unless we pay the
Other questions are there, my lord. Your lordship may be pleased to see page 5.
I have seen it.
I have taken that point, my lord. Whether in consideration of one appeal, the learned appellate court is entitled to decree the suit and set aside the decree of the counterclaim when the decree of the counterclaim is a separate decree. Next, my lord, whether without any specific prayer in the plaint, the plaintiff is entitled to for any decree for specific performance of the contract when the plaintiff is to prove specifically about his readiness and willingness. Because trial court completely rejected that he is not ready and willing, my lord. Then in plaint also he has not disclosed anything, my lord. Then
can we in second appeal decide this issue? Because we have to appreciate the fact.
Yes.
Beside the question of readiness and willingness. Second appeal perhaps we can also go into the fact.
It can be,
my lord, in a case of specific performance of the contract, my lord, my lord, readiness and willingness is essential ingredient. There are several Supreme Courts, my lord. Trial court fully discussed these things, my lord. Because he stated in the plaint that he applied for a loan for purchasing the land, my lord. But that was not proved, my lord. Not a single document was passed. That was the trial court rejected these things, my lord. There is no pleading that he is ready and willing to perform his part of the contract, my lord. So I have taken this ground as ground number 2, my lord. Another ground, my lord, whether the suit of the plaintiff fulfilled all conditions of specific performance of oral contract when he failed to prove about the sanction of the loan for the LS payment of balance consideration. Then, my lord, next, whether the judgment of the learned lower appellate court is justified in passing the decree of the suit without discussing the evidence on record and shifting the burden on the defendant. Here, my lord, the case is peculiar. The appellate court shifted the burden on the defendant that you are to prove. Then last, my lord, the learned appellate court decreed the suit on the basis of the schedule of the pain, which is denied by the defendant, as the contract is oral of the defendant the learned appellate court believing the schedule of the plaint to be correct is not tenable in law and purport.
A single
Lordship, I have also enclosed the plaint. In para 6 of the plain matter at page 11 matter, he simply stated that as per the aforesaid verbal agreement, the plaintiff applied for a loan of rupees 8,05,000, 50,000 only from Housing Development Finance Corporation Limited, which was approved by the said corporation, but not a single document. The trial court, appellate court will believe that the loan is sanctioned, that is sufficient. Para 7, my lord, from the aforesaid letter dated so and so was only a formal approval letter from the bank, which is subject to fulfillment of other conditions. So loan is although granted according to him, but other conditions were not fulfilled till now. For that, my lord, he prayed for agreement for sale, NOC from the competent authority, these things, my lord. So registration of the sale deed is subsequent. First, these two things should be completed, and after completion of that, my lord, the loan will be granted to him. So where is his specific statement that he is willing and fulfilling the condition? That is an oral agreement according to him. And the specific relief act, my lord, section 16C is very specific that he has performed and has always been ready and willing to perform his essential terms of the contract, which are to be performed by him. Trial court fully discussed, my lord. Appellate court, my lord, without considering these things, my lord, allowed and dismiss the contract.
Let us do one thing. We adjourn the matter today. You produce this decision of the Supreme Court. So then night SCC.
That was only one point, my lord. The other points are there. I have already stated.
That's all right. Because another matter is pending. Whether it will appeal or to appeal, both to have been filed for the appellate.
If that point also gone, my lord, there are other subjects.
Only not only that point, my lord. Other things are there. Because his plaint does not disclose
essential ingredients of
essential
specific
contract.
What is this?
Today you can produce money. Today you can produce 2009.
Not today. Another matter is pending. Therefore, I adjourn it. Both which that you will be
Tomorrow, my lord.
So we'll list this matter along with that matter. Most probably this week, last part of it. Will you give the date later? Will you check the other case?
My lord, this second appeal is preferred, my lord, against the judgment of rebuttal of the civil judge, my lord. Senior Division against the decree passed by the Civil Judge Junior Division in a matrimonial dispute suit. The suit was a declaratory suit for declaration of the divorce pronounced by the appellant husband hearing. So the decree was passed by the trial court in ex parte, my lord. The wife did not contest, did not file the WS, and did not participate in that trial. The decree is reversed only on the ground of jurisdiction. The learned civil judge senior division held that the civil court has no jurisdiction, but the fact is that, my lord, in the Hainakal district, there is no family court. The Section 7 of the Family Court Act provides that, my lord. Section 7 excludes the jurisdiction of the civil court, of the Family Courts Act. For a moment. So it is not disposed on merit, it is disposed, the decree is passed on jurisdictional ground only. Section 7, Family Court Act. My lord, the civil judge finding is, judgment is page number 6 and page number 12, my lord, the finding. May I read, my lord, the finding, my lord? Point of decision.
Which one we have referred to?
My lord, 7 of the Family Court Act. Subject to the other provisions of this act, a family court shall have and exercise all the jurisdiction exercisable by any district court or any subordinate civil court under any law for the time being in force, in respect of suits and proceedings of the nature referred to in the explanation, and be deemed to, for the purposes of exercising such jurisdiction under such law, to be district court, or as the case may be, such subordinate civil court for the area to which the jurisdiction of the family court extends. Now, my lord, explanation, the proceedings, explanation A, there is the dissolution of marriage. But the fact is that, my lord, in the Hailakandi district, there is no family court. So where there is a family court, then the question of exclusion of jurisdiction will come, my lord. The question was that whether in the absence of family court, the civil court had the jurisdiction. Finding, my lord, of the learned civil judge, first appellate court is page number 12. Whether the civil court presided over by the learned civil judge has got any jurisdiction to entertain the suit relating to the dissolution of marriage. But in the point, it is absent that in the absence of family court. Perusal of the pleading of the parties as well as the evidence on record reveals that the plaintiff had initiated the suit for the dissolution of the marriage on the ground of triple talaq pronounced by him on 3 different dates. Now, if we see the forum before which the relief is sought for is a court of civil judge junior division, which is in my considered opinion has got no jurisdiction to entertain the declaratory suit relating to the matrimonial disputes like dissolution of marriage. The proper forum competent court of the lowest grade is the subject matter of the suit, which is not the ordinary civil suit, rather is a family suit, which is governed by its own specific laws, procedure, and objective. In my considered opinion, would be the family court. If the family court is established for an area as per section 378 of the Family Court Act, and if no family court is established, then it would be the district court with family jurisdiction. It is the finding of the civil judgment, but it is not backed by any law, or any provision of law. This finding, and we know that in view of section 2.4 of CPC read with 3.7 of General Clauses Act, and section 2.4 is regarding the district judge, and read with section 3.7.17 of the General Clauses Act, the district court with family jurisdiction would be the principal civil court. It is not there, my lord. May I read the two provisions, my lord? District court with family jurisdiction is not there, my lord. in these two provisions. That is the Honorable District Judge.
Oh, tell me, sir, which provision the suit was filed before the complaint?
My lord. Suit is a declaratory suit, my lord. The divorce is already pronounced, my lord. Only for declaration, my lord, may I go for the trial court judgment, my lord, page number 25. Page number 25. And relevant part is page number 26, my lord. 26, the second paragraph. "25 are the two issues, my lord, and 26 is the regarding the filing of the suit, my lord. Before going into the decision in the matter, it is firstly to be mentioned that the plaintiff is seeking declaration. Lord, may- "26 above, my lord, I am reading. Before going into the decision in the matter, it is firstly to mention that the plaintiff is seeking declaration that defendant is his divorced wife, and he is not seeking divorce from the defendant in the instant suit. From perusal of the plaint, it is seen that plaintiff already divorced his wife. So, my lord, as per Muhammadan law, the talak-e-Hasan is a form of talak, my lord, where the three talak is pronounced in three consecutive months, my lord, to her period, my lord, in between the two menstrual period, my lord. So, in this case, my lord, the three written divorce, my lord, sent by the plaintiff, my lord, to his wife. That is talak-e-Hasan. Here it is talak-e-Hasan, my lord. So the plaintiff is in the plaintiff already divorced his wife, defendant number on three different dates, as mentioned above, by pronouncing talak for 3 times within an interval of 1 or more months. So, as per Muhammadan law, the talak is already given. Only a declaration is required from the court, my lord. So, it is a declaratory suit. It is not purely a divorce suit, my lord. It is not purely a divorce suit to pronounce a decree of divorce. It is not a case of a decree of divorce, my lord. It is only a declaratory suit, and it is clarified by the learned trial court, my lord. Trial court only declared that it is already effected. So it is not a decree, a suit for decree of divorce, my lord. It is, I will try to clear your lordship. It is not a suit for a decree of divorce, for passing a decree of divorce. Divorce are already effected, my lord, after pronouncement of 3 talak, my lord, written talak, exhibit 1, 2, and 3. Exhibit 1, 2, and 3 trial court, 3 written talak is, my lord, sent to the wife, and the wife did not contest this suit, but in a my lord, in another case, my lord, filed by the domestic violence case, the wife, my lord, admitted that she has received the talaks, and that is on record of this court, my lord, of this proceeding. The plaintiff has submitted those evidence, my lord. And in the domestic violence case, the wife admitted that she has received the three written talak. So the trial court has already clarified that it is not a, my lord, a suit for decree of divorce. It is a declaratory suit. Already the
maybe declaratory suit, it may be a declaratory suit, but concerning the marriage. Concerning the marriage between the parties.
Marriage, yes. But my lord, as per Family Courts Act, if there is a family court, then the civil court jurisdiction is excluded, my lord.
No,
Otherwise,
where there is no family court, that's the court of district judge.
There is nowhere is mentioned there that my lord. Yes.
You see, there are many districts in Assam where this family courts are not established.
Yes, my lord.
In those districts, the issues are being dealt with by the principal district judge. District judge.
No, my lord. Regarding my lord, 125 proceeding also, my lord. 125 proceeding where the wife seeks from husband the maintenance, specific provision. There also the judicial magistrate first class has the jurisdiction to entertain such.
Yes. Where the family courts are not there.
Not there.
There the magistrates are dealing with the.
Yes, my lord. And
but here declaration concerning the dissolution
marriage.
of the marriage.
Yes, this is also a matrimonial, my lord. But there is no, my lord, provision is there that in the absence of family code, the district judge will have the jurisdiction, my lord. Nowhere it is mentioned, my lord. And as per section 9, my lord, of the CPC, all civil matters, the civil code has the jurisdiction, unless, my lord, unless it is expressly or impliedly barred, my lord. Section 9 is there, my lord. So the appellate court's finding is not backed by any.
No, cannot be said. The finding of appellate court is perverse or without that reason. That cannot be said. Because in districts, in those districts where family courts are not there, the matters are dealt with by the district judge.
As per my knowledge, my lord, personal knowledge, my lord, I have inquired also in the other district, my lord, where family court is not there, my lord. The civil judge, my lord, the divorce matters, mainly in case of this under Muhammadan law, where the talak is already pronounced, the declaratory suit is filed in the civil judge junior division, my lord.
Whether such cases are pending for this court?
Yes, my lord. In the civil judge junior division, several cases pending, and the decrees are.
No, before this court.
This honorable court. I have no.
You can find it out.
I have no input. I will. Go ahead.
The agenda matter. Part Mr. M. Dekadit, learned of Appellate. This is the matter on court. After 20.
Oblige.
For further consideration.
Oblige.
May I please? My lord, other side, my lord, my lord, RSA. RSA, my lord, already admitted on 26 to 2024. My lord, it was filed by my lord.
Now execution started. Execution proceeding started.
No. My lord, I have filed, my lord, for
application is for stay.
my lord, I have filed, my lord, for granting my lord injunction because my lord, in paragraph 8, my lord, I have stated after my lord getting admission of the RSA, my lord, the other side, my lord, is by engaging JCB, my lord, started earth filling, my lord, and erecting RCC wall in a portion of 1 bigha of land. So, my lord, this petition is filed, my lord. In para 8, my lord, I have stated. So, my lord, my lord, injunction in the form of a status to my lord. If my lord granted, the other side also and my side also, nobody will, my lord, do anything in the, my lord, this scheduled land. Till disposal of RSA matter. And it will harm nobody, my lord. Other side will also not be harmed by granting order of status to mother.
May I please? My lord, this lordship, this application is not maintainable otherwise. My lord, lordship, kindly have a look. The order 26/2/2024, whereby this honorable court state the judgment, my lord. Just I am reading for lordship's consideration, my lord. Since the connected regular, my lord. 26.
Order?
Yes.
Order?
26/2/2024 order of this honorable court, my lord, in main case. Everything will be transparent. Lordship can decide the matter.
Yes.
Lordship, since the connected regular second appeal is admitted for hearing, the judgment and decree dated 10/1/2023 passed in title appeal number 3/2022 by the learned civil judge Udalguri shall remain state till disposal of the appeal. The entire application is disposed. Now, Lordship will find another order regarding the substantial question of law. And it is necessary to brought to your notice, my lord, regarding substantial question. May I read?
No, it's
No, my lord, only
not listed today.
no,
It
no.
will be the
I'm to that effect, my lord. I will come. My lord, the substantial question, just for your lordship, and I will go to the main IA case. Whether the learned appellate court below can decide the plea beyond the pleadings of described schedule of the suit land as against the settled law. My lord, their suit land is different, and my land is different. Their DAG number is one. They are claiming 110, and my is 111. Whether the judgment and decree passed by the learned first appellate court is bad or non-compliant with the provisions of order 41 rule 31 of the CPC. No points of determination with regard to the issue, my lord. Now, my lord, here in the case, my lord, in the case, my lord, IA, this application has been filed by them, my lord. Lordship will find that in the application they have stated that their DAG number is concerned with the 111. Whereas my DAG number is the different. And when the pleading itself does not lead the evidence, my lord, the beyond the pleadings, my lord, they cannot claim anything else, my lord. It is obviously clear. Yes, and now, my lord,
But
when
the technical land you maintain.
yes, my lord, now yes, now I am in the possession of the land since 2007, my lord. And it was even in the in the evidence, my lord, it has been clearly stated that he has no locus standi in the land, my lord, in the schedule of the land. My lord, how this application will be filed then? My lord, since he has no locus standi in the schedule of the land, how this application will be filed, my lord? And to that effect, I have filed an objection, my lord. Yes, my lord, I have.
Not on the record.
It was filed objection, my lord, on 29/7/2024, my lord.
Are you sure that you have filed it?
Yes.
What is the number?
No. Number is, my lord, objection in their IMI.
That's all right, but it is not on the record. Not in the system also.
It is there, my lord. 7/8/24.
Go and inquire in the section. It may be in the defective file. Third Mr. Sopan Bernard for the applicant for respect Bernard not complete verdict. Third, that not 2025. If file but objection but the text not present record. Provided that this letter on next week, including the objection filed by Bernard also. So, Sohan, have you received copy of the?
No, my lord.
No.
Objection to this, sir?
My lord, I have checked in my file. It is not there.
Objection. This is to object, right? The day you have said that I have received it. Now you are saying to give. Say to give.
Yes, my lord, copy.
You have received it.
1640. No.
Oh, yeah. Say to have.
76.
Oh, yeah.
So, actually, you go and inquire from the
Yes, yes. Lordship is fixing that.
next week. We have not been the date.
Item 22. Can it be some 21 or like? Because this has to be disposed of.
21. Much.
But there is a delay of 38 days in preparing the testamentary appeal. They have filed their objection. In fact, the affidavit in opposition. Only one ground they have taken that we have not annexed the complaint that we have filed before the Bar Council against the concerned advocate, because of whom we were not aware about the judgment passed in the testamentary case. They filed the objection on 7/8/2025.
That is the only ground.
Yes, this is the only ground. Paragraph 6, in their objection. And 8. The 8, they have clarified that if the allegations brought against the learned advocate who represented applicant complaint should have been filed against the learned advocate, but the said has not been reflected in the application, which compels to believe that the ground for condemnation of delay 38 days in filing the testament may not be correct.
But it's the main ground that have taken.
The main ground, my lord, we could not
Paragraph number. Where you have explained.
Paragraph 4, we have explained that the appellant states that in the aforesaid case on 17/12/18, the learned court directed the appellant to take steps fixing 18/18 for service report. However, a perusal of the order sheet goes to show that on 18/19, there is an order that no proper step was taken. Therefore, the respondent petitioner was again directed to take fresh steps fixing 9/4/19 for service report. On 9/4/19, as per the order sheet, it is seen that the appellant petitioner did not take any step, and therefore the learned court directed the petitioner to take steps within 7 days fixing 7/6/19 for service report. Be that as it may, though the appellant formally did not receive any notice of the aforesaid case, but Mr. Horiboto Chandra's advocate informed me about a pending litigation in connection with a will allegedly executed by the appellant's mother. He informed me that the case is pending before the learned court of the Additional District Judge FTC Kamrup. Mr. Chanda, advocate, further informed the appellant that he had to contest the matter in court. Upon his insistence, and since he is known to me, the appellant engaged him as a lawyer in the proceeding which was pending before the Additional District Judge number 3, Kamrup. That the appellant states that as per the order sheet on 30/11/19, Mr. Chanda, advocate, appeared before the learned court by filing the Vakalatnama on my behalf, along with a petition being number 2133, praying for some time to file objection. The learned court allowed the prayer made by the learned advocate and fixing 3/2/20 for objection. Next, the appellant states that thereafter on the next date, that is 3/2/20, the learned advocate did not appear before the learned court and the matter was fixed on 27/3/20 for necessary order. Thereafter, due to the prevailing pandemic, COVID-19 at that point of time, the court was not functioning, for which the matter was adjourned on several dates. Thereafter, on 25/1/21, when the matter was fixed for passing necessary order.
Okay. So their main object, complaint was filed like the concern.
This is the only object.
Whether
No, we have not annexed along with the condonation petition. In fact, we have annexed along with the main appeal we have filed before this honorable court. Page 30. 33. Sorry.
the memo of appeal. They have received the memo of appeal.
No, my lord, because the delay has not been condoned.
Copy has not
Yes.
been Have you copy from
Yes, we have a copy.
part?
I have given the entire memo of appeal.
Let us consider
Objection will be
copy the property lodge the complaint in the court.
actually objection
That's
will be
what he can do.
objection will be recorded.
Or the learned. Then or the
Z doctor.
Z?
Z doctor.
By the 5 days. No. 38 days.
Within
38 days. 5 connected testamentary appeal. Judgment dictate.
respondent.
The date is
Date.
judgment.
My lord, this paragraph 7.
Judgment dictated
7/6/24, after recording the evidence adduced on behalf of the petitioner, the learned court was pleased to dispose of the Miss Probate case 46/18. 7/6, no? 7/6/24. Yes.
early. But the
Paragraph 2 also it is mentioned.
judgment order dated 17 but they are learning the probate it 46 of all services learning the applicant substance on account of Kaila on the part of the object the learned the probate court applicant hearing that of the
Very good. Very good.
of
Okay. Probably.
and therefore the applicant could not be filed in time and the change is not other it's a then at that particular point the appeal which is to part of credit and other factors that although the delay of part it the Dr. Learned Council of how both the on the ground that the ground that the on the ground that complaint has filed against the contract of the part. However, it hurt yes, the ethic of the and that view of the matter the objection raised by the party both the part appears to not satisfactory. On the other hand, the explained outcome related by the appears to have been sufficient therefore allow this appeal by consulting party by the order of I not
We have given the memo of appeal and the stay application. It may be recorded in the order, otherwise in the and the appeal may be registered showing their name, reflecting the name of the council.
the learned for the opposite party of a subset of part the learned subset by of the
Timing item.
May I please, Your Honor? May I please, Your Honor? Lordship, by filing this revision petition, Lordship, the petitioner has challenged the impugned order passed in Ms. G case number 65/2024, passed by the learned principal judge, family court number 3, by which the learned principal judge, family court number 3, has curtailed sufficient visitation right of the petitioner, Lordship. That's why we have approached this honorable court. Lordship, what happened? Petitioner is the husband and the wife is the respondent in this case, Lordship. They got married in the year 2012. Thereafter, after 7 years of their marriage, Lordship, they were blessed with a baby boy on 29/2019, Lordship. The baby boy is now about 6 years old, and with respect to the visitation right of the petitioner to his son is the subject matter of the Ms. G case, Lordship. Lordship, had impugned order dated the learned principal judge family court, it has given interim custody to the respondent, Lordship, and we never objected with respect to that. But as well as the learned family court number 3, principal judge family court number 3 has curtailed visitation right to much extent, Lordship. The learned trial court has allowed us to meet for 3 hours on second Saturday or Sunday, second Sunday, and on fourth Saturday and Sunday. 3 hours, 6 hours in a month, Lordship. And not only the petitioner, the minor son is also suffering from disorder, Lordship. That's why I have approached this honorable court. Lordship, by passing this order, when the learned trial court has curtailed sufficient visitation right, Lordship, earlier honorable court was pleased to order sufficient visitation right to the petitioner, Lordship. But thereafter, after an objection filed by the respondent, Lordship, the learned family court number 3 has sent her own order, Lordship. And thereafter, we are suffering, Lordship. What happening, Lordship? The second Saturday is, though it is a holiday, but the petitioner is not allowed to leave his station, Lordship. He due to his job, he is residing at Lakhimpur, Lordship. So now the situation is this, Lordship, only 3 hours in a month the petitioner can meet the children. Whereas the children is also willing to miss, he used to miss his father, Lordship. Over telephone, Lordship, he always cries, always asks the father why he has not come to meet him regularly, why he is not residing with the father. Therefore, Lordship, finding no other way, the petitioner has approached this honorable court seeking revision of the said order, Lordship, as because the minor child is much more suffering, Lordship. Lordship, I have in my ground of my revision petition, Lordship, only I have stated in page number 9, Lordship, that the impugned order has violated the basic human rights of the minor child, Lordship, as because he has lost love, affection, and company of his father, Lordship. Moreover, Lordship, for not giving sufficient visitation right to the petitioner, the minor child will, Lordship, lose social, physical, and psychological contact with his father, Lordship. And for this impugned order, Lordship, for not giving sufficient visitation right to the petitioner to meet the minor child will immensely obstruct in improving the bond between the 5 years minor child and his father, Lordship.
Moreover, Lordship, the learned apex court has clearly stated that sufficient visitation rights should be given to the other spouse whom custody was not granted. Lord. In this regard, Lordship, I beg to submit a decision of Honorable Apex Court Lordship. Lordship, in Deepak Gupta versus Aniruddha Bose case, Lordship, 2000 AIA 2020 Supreme Court 577, Lordship, it has been specifically stated by the Apex Court, Lordship, in second paragraph, Lordship, every separation, every reunion may have a traumatic and psychosomatic impact on the child. Therefore, it is to be sure that the court weigh each and every circumstances very carefully before deciding how and in what manner the custody of the child should be shared between both the parents. Even if the custody is given to one parent, the other parent must have sufficient visitation rights and to ensure that the child keeps in touch with the other parent and does not lose social, physical, and psychological contact with any one of the two parents. It is only in extreme circumstances that one parent should be denied contact with the child. Reason must be assigned if one parent is to be denied any visitation right or contact with the child. Court dealing with the custody matters must, while deciding issue of custody, clearly define the nature, manner, and specifics of the visitation rights. The concept of visitation rights is not fully developed in India. Most courts, while granting custody to one spouse, do not pass any order granting visitation right to the other spouse. As observed earlier, a child has a human right to have the love and affection of both the parents, and court must pass orders ensuring that the child is not totally deprived of the love, affection, and company of one of her or his parents. Normally, if the parents are living in the same town or area, the spouse who has not been granted custody is given visitation rights over weekends only. In case the spouses are living at a distance from each other, it may not be feasible or in the interest of the child to create impediments in the education of the child by frequent breaks. And in such cases, visitation rights must be given over long weekends, breaks, and holidays. In case like the present one, where the parents are in two different continents, efforts should be made to give maximum visitation rights to the parents who is denied custody. In addition to visitation rights, contact rights are also important for development of the child, specifically in cases where both parents live in different states or countries. The concept of the contact right is modern as would be contact by telephone, email, or in fact, if available between the parties, should be video calling, which is increasing available of internet. Video calling is now very common, and courts dealing with the issue of custody of children must ensure that the parents who is denied custody of the child should be able to talk to her, his child as often as possible. Unless there are special circumstances to take different view, the parents who is denied custody of the child should have the right to talk to his, her child from 5 to 10 minutes every day. They will help in maintaining, improving the bond between the child and the parent who is denied custody. If that bond is maintained, the child will have no difficulty in moving from one home to another during vacations or holidays. The purpose of this is, if we cannot provide one happy home with two parents to the child, then let the child have the benefit of two happy.
Sharma,
Yes.
you come to last part of the order, where
The impugn order, Lordship.
yeah, it is stated that for second Saturday struck Sunday and fourth Saturday struck Sunday of every month or on any holiday at least 2-3 hours from 10 a.m. to 12 p.m. struck 1 p.m. or 4 p.m. to 6 p.m. struck 7 p.m. in any public place as park, mall.
Yes, Lordship. Here is problem is this, Lordship. The
if on Saturday you cannot leave the headquarter, on Sunday you can leave the headquarter. You can meet.
Only 2 Sunday for 3 hours. It is not sufficient, Lordship.
No, it is also mentioned or on any holiday.
The problem is that, Lordship, the school where the children is reading, the holiday, the state holidays not, they are not following the state holidays, Lordship.
But have you pointed this out to the learned principal?
Yes, Lordship. We have verbally stated after passing of this order, Lordship.
After passing of this.
As because the after passing of this order, the case was
Advising the learned principal, the family court before passing the order.
Lordship, before passing the order, we have no idea that the order would be like only all holidays and second Saturday or fourth Saturday, Lordship. Hereafter, the matter was sent to the councillor, Lordship. We have also raised that issue here, Lordship, but no fruit was come out, Lordship.
Yes.
Yeah. Sensitive matter, my lord, cruel matrimonial dispute arising out of this tug of war for the minor child. My lord, will kindly see 106, that page, the first order that was passed by this, my lord. And at page 109, my lord, will kindly see the observation of the court. Yes, it is very much important for the welfare of the child to have the bond rakas in the whole neighborhood, my lord. And these afterwards, my lord, ultimately goes to the school, my lord, disturb whole of the environment there, my lord. And the child being suffering from that. That's the feedback we have got in. We have pointed out to the trial court below, my lord. And trial court below has passed this order after hearing both the sides, my lord. And there is no unjustified ground appears here, my lord. And if he wants something with regard to the hours of meeting, my lord, wherein from 10, 11, 12, 3 hours, make it 5 hours, no issues from my side, my lord. But it should be something, my lord, time frame and along that whenever he comes in and tries to, my lord, create a situation, that should not be allowed, my lord. That should not be allowed. Otherwise, my lord, there is nothing infirmity in the order.
Cannot the statement because of
Yes, Lordship. I can leave the station in every weekend. 7 except second Saturday, Lordship. In the
okay, on Sunday you can make it.
yes, no,
that
every
is here in the
Sunday I
order.
have not been allowed every Sunday, Lordship.
Who had not allowed?
The learned trial court has not allowed to meet us every Sunday.
See the order.
Yes, my lord.
Second Saturday, struck Sunday.
Yes.
Fourth Saturday, struck Sunday.
Yes.
Then
The explanation.
May I please, your lord, like to mention one item, my lord, now regarding court number 8, my lord, urgent matter, my lord, because the accused is behind the jail for this 9-5 and mandatory period is already over. So can it be listed tomorrow, my lord? Court number 8. Today,
that court will be available.
yes, that court will be available, but it is not listed not tomorrow, but your lordship directs for listing it tomorrow, my lord. Number 29, my lord. Court number 8. Must
But the TIS status shows that the respondents had filed an Wakalatnama. We had served by Dusty also, but then the Dusty affidavit also we could not file because the person from Silchar could not come. However, I have the acknowledgement receipt of the thing. And Wakalatnama is already filed as far as the sole respondent is concerned. What's the name of S. Das appearing for the Yes.
Acknowledgement. Notice acknowledgement.
That is after 2 days.
Hello.
In the meantime, the Kulanama is not available with the record.
Hello. Maybe
That has been filed.
only file.
The system shows that it's filed.
Hello.
In the meantime, you also filed your
My lord, the
affidavit.
affidavit, yes. The person could not actually come from filter. Though I have the acknowledgement, he could not come and swear, my lord, the affidavit. It's the thing today, probably.
Let it be Wednesday.
Hello.
Thursday.
Thursday.
Or the part of it is this product also that has filed. Is the matter on Thursday.
In interim order to
In the
continue.
meantime, office that put up and up to the regarding file order password.
Deeply offended.
Made resolve. My lord,
I suppose it was not the Esther where Ukalanama was filed.
which my lord,
Satyajit. You are not Satyajit.
no, my lord.
You are Esther.
I am it. My lord, this is actually, my lord, a challenge against a land grabbing order, my lord, which was initially, my lord, registered as a writ petition, my lord. Subsequently, it was converted into a CRP, my lord, and it was admitted, my lord. The parties have arrived, my lord. And then on the earlier occasion, my lord, LCR was called for, my lord, but that LCR has not been received by postman.
There was called for
From the court of, my lord, additional district judge, my lord, Kamrup.
Yes.
Yes, Kamrup.
Or the test does start. Sir?
K Talukdar.
Pardon?
K Talukdar.
K Talukdar. 5 days with it's healthcare not it. According to it is provided that urgent reminder the learned court below. So transmitting the record of court after 1 week.
My lord, in the meantime, can there be any protection, my lord? Because execution case is still pending. And my lord, without any protection, my lord,
At 1
at my lord, steps have already been taken, my lord. It is fixed perhaps for report on 27/8.
there any date was
27/8. 27/8 of this month.
before that day.
My lord, before that, my lord.
You are appearing on behalf.
Respond number 1, 2, 4, and 5.
You have filed
Yes, your lord.
I am for PP, on behalf of PP Dasma. Hello.
So now here he is the auction purchaser, my lord. Auction purchaser, the dispute between the bank and the my lord loanee, it's going on in the DRT tribunal, my lord. And there I also included as one of the party, my lord, in my application because there are some trouble, my lord, getting the land. Although I have purchased deposit more than 6 crores, I'm not getting the possession of the land. Therefore, I file an application there and implemented. But my lord, what happened? Page 13, and my lord, I wanted to give some more documents, but my lord, that has been refused. Against that, I have filed this revision petition, my lord, so that few documents only may be allowed to my lord submit before the court, so that in the there should not be any dispute between the my lord bank and the my lord giving possession of land to me.
Right.
And the documents are here. And in the meantime, my lord, the 10th September is my lord fixed for disposal of the final order. So before that, if it is not disposed of, then my petition will be infractious here.
And I have also filed an affidavit in this case, my lord. Today, I have also filed an affidavit in this case. I am the borrower.
Today.
Today, I
Who is the
filed.
borrower?
Let it come up on 14. The lordship may hear it. Here. On
14.
On 14.
14,
14 August.
14 August. Let it come on
14th day.
no, after 3:10.
10.
Because your lordship will see from this order, yes, from this here, from this order, here the auction, that is the petitioner had also submitted his argument as well as written argument. If I may read, lordship, this order. Just a minute, Let me just apprise this honorable court. Kindly, the last part here, lordship. Learned counsel, Mr. R. Kapoor, that is the counsel for the petitioner, has appeared for respondent number 5 auction purchaser, that is the petitioner, and files written notes of argument. Argument heard, fix the matter on 10/9/2025 for order.
Yes,
Their counsel has appeared and submitted written statement, written argument.
That is a different issue.
No.
Since bank is unable to give me possession, I wanted to submit some more documents regarding the land. Therefore, if it is fixed on October, this petition will be infractious. If your lordship kindly allow me to submit these documents, 8 documents, only regarding the land, then my lord, my case will be easier because I have deposited more than 6 crores. But my lord, so many.
But whether if I file a petition for allowing you to submit documents.
Yes, ma'am. That has been rejected. That is the order at page 13. And 11 page, your lordship will see 16. Yeah, 16 then. The bank is bound to remove such obstruction. The petitioner, respond number, page 16, my lord.
Yes,
From the beginning, yes. From the beginning, yes, my lord. Remove the difficulties before, my lord, from, it's when I don't want to bother, my lord. It's a long order. Therefore, last line of your lordship may read from page 15. The secured creditor or bank has the right to file additional documents regarding the property, and it is for the bank to remove difficulties before selling out the property through auction. The bank is bound to remove such obstruction. The petitioner respond number 5 is a third party and a stranger to the mortgage deed. Therefore, he has no locus to challenge the validity of mortgage deed. The petitioner is not seeking to assert any ownership to respect to Doug number so and so, so he cannot make any comment or observation with regard to the ownership and possession of the surface applicant in respect of Doug number so and so, of sale deed number so and so. The supported documents have not been any relevance, pouring of or connection to the issue forming the subject matter of the present essay. Moreover, the petitioner has not given any particulars as to the date and time when such documents came to the knowledge of the petitioner. No explanation has been provided by the petitioner as to how the petitioner could not have obtained copies of the said documents prior to point of time, in point of time. The said documents are of measure of public records, and as such, there is no reason as to why the petitioner who could not have obtained the access of the said documents prior to the point of time. In view of the above, I do not find any so and so, it's rejected. This is the case, my lord. And out of 20 documents, I want to have given a list, my lord. Let's kindly see. Only 8 documents are new. List is that, my lord, page 9.
You see, if the documents are of matters of public record, then why it is not?
Yes.
Because of, my lord, transfer of the office, my lord. DC office from here to, my lord, this Hangarabari. So, my lord, for few months, yes. For few months, 6-7 months, they did not provide any document. So there are some other reason which petitioner cannot help. The documents, my lord, if page 19, certain documents are there, my lord, that I've given a list of documents. Out of that,
that is why I filed a counter affidavit explaining that out of those 8 new documents, there is no explanation given which document came to her knowledge at what point in time, why she could not obtain, whether due diligence was exercised, why she had to adduce these documents at the stage of final hearing. Now that the suit has already, in the surface application has already been concluded. Secondly, these are all matters of clouding the title or dispute of title ownership of the land in question. Therefore, she ought to have filed a civil suit. She has not gone there. I have filed a civil suit for declaration of my right to redress. The petitioner is arrayed as party therein. Therefore, the petitioner has not participated in my civil suit, but is resorting to my surface application by way of an IA to obtain reliefs. This is an indirect way of going about, and this is misuse of court process. That is why my record is
part will be decided between the bank and them. I have nothing to do. Being the auction process, I am deprived. Depositing the money, bank is unable to give me the possession of the land. That's all.
Because there is a stay operating
not a,
in the essay. There is a stay operating, and all they have been impleaded as a party. They himself got impleaded in the proceeding before the DRT, and they have argued the case. They have filed all sort of affidavits, written arguments concluded, is fixed for order. Now, so far that the senior counsel is reading that order, if she is aggrieved, then she ought to have filed an appeal before the DRT, because the alternative remedy is there under section 18.
And this topic of 8/1/2025 was previously challenged by way of another CRP in March. Liberty was granted to file additional documents by this honorable court itself. After waiting for 2 months, this new CRP has filed challenging the same 8 January 2025 order.
that cannot be. Liberty was given. It was withdrawn and liberty was given.
In the meantime, on April, another IA on the same cause of action has been filed. I have annexed this IA in my additional affidavit.
Earlier, allowed the file document.
Yes.
Yes.
That order is there.
That order is there, but in the meantime, she did not approach this honorable court with the fresh CRP intervening period. They filed another IA on the same cause of action to file additional documents which they have not mentioned herein. There has been multiple instances of concealment of material. That is why I am praying, my Lord may take it up on 14.
Phrase 89, my
affidavit
lord,
will be very relevant. I'll be referring to these orders.
What he is, my lord, accusing, your lordship will say in page 89, and so on behalf of the petitioner, submit that there are various documents which ought to have been enclosed along with the petition have not been done. She may be permitted to withdraw the present petition with a liberty to refile. Taking into account the above the instant petitions, then the withdrawal liberty is being. So accordingly, on page 89, I filed this.
And the additional documents that were
cannot be a ground
under
for objection.
IA, and my affidavit in opposition in the IA. These are not documents, these are pleadings. He has basically attached pleadings in this second CRP.
List of
no additional document. That comparison, I also have the first CRP as well. That is why
I have given the list of documents. Your lordship will kindly see where is the argument. Where is the argument? Page 19 it starts. Out of 20 documents, only 8, my lord, affidavit of document 3, document 7, document 11, I want to submit, document 13, document 15, document 16, 17, and 18. Other document already you have submitted, only few documents.
And why these documents are relevant?
No, I'm concerned because this is between bank and us.
It
I have
cannot be a
nothing to
roving
do with
inquiry,
you
madam.
because you are a
Cannot be a roving.
you are a defaulter or whatever it is borrower, but I have nothing to do with the loan part. I am concerned with the bank. Bank is not giving me the possession.
And the bank is a performer party.
Bank has to be honest. If they are selling some property, they are, my lord,
I am the main
they are
party.
bound to
Bank is
possession.
This is a contradictory argument. What is being placed before the DRT?
In the matter on 14th of August.
We have
In the
14th
meantime,
August.
let the affidavit
Yes.
heard and petition heard, petitioner and other- yes. Yeah, good time.
Yes, Doctor.
Yes.
Doctor.
Yes. Response number
4 and 5.
4 and 5. The board of
And our respondent 2.
respondent number 2 po. Then who is respondent number 1 and 3?
Well, no workout number is not filed, but respondent 2 is the proprietor of respondent 1. So I can competent respondent 1 as.
Okay. The board of learned number object number and the same not placed on record. According to provided object file.
We will file one short affidavit.
14.
Short affidavit within 2 days.
Number 4 and
4.
4.
Obliged.
May I please?
Yes.
But if this IA is for declare compromise under order 23 rule 3 or
Where is the other part?
that particular lordship I have contacted, he is out of session. So he in fact, yes, day after tomorrow he will be available, lordship, if possible, subject to your convenience.
Okay. The pair being made by Mr.
THO3.
Learned for the application, rest the list of 40.
Day after.
18.
Obliged.
Yes, yes.
My pleasure.
Yes.
Lordship, with this, the present appellant has filed a title suit for declaration of right title interest, recovery of descheduled property, and permanent injunction. Initially, the injunction was granted in favor of the plaintiff appellant, Your Honor, and both parties were directed to maintain the status quo. The respondent and the appellant, Your Honor, the respondent is the uncle and the respondent plaintiff is the nephew, Your Honor. So, in the 2005, Your Lordship, a family settlement deed was executed between the two brothers, Your Honor, that Your Lordship will, a family settlement deed, Your Lordship will get at family. Page 18 of the Powell, IA, sorry, IA 2121, page 18 is the family settlement deed. This is the family settlement deed. Original Xerox also I have filed. Your Honor, Mafizur Rahman and one Bhuken, Mojirul Hussain, they were the brothers, Your Honor, own brother. So they had partitioned the property by which they had by this family partition deed, they had also separated the shares of their sons, your Lordship. And that Your Lordship will get at page Page Lordship 25, Lord. Page 25. Last column, Your Honor, clause 1. The first party, in order to settle the dispute amongst the sons, namely Muhammad Mujibur Rahman, Rejibur Rahman, and Atikur Rahman. Atikur Rahman is the defendant respondent. Born out of the wedlock with late Manju Nisha, allowed them to possess and enjoy the total plot of land described in the Schedule A herein, way back in the year 83-84. Absolutely, as per the said settlement. Then clause number capital A, Mujibur Rahman. Mujibur Rahman, Your Honor, was the father of the present appellant plaintiff. Rahman has been possessing the first floor of the second floor of the RCC building constructed by the first party himself along with a some type house under holding number so standing in the name of the second party. The staircase leading to the first floor and the second floor of the RCC building is situated on the western side of the building, leaving the entry to the ground floor of the said building, which fall in the share of Atikur Rahman, that is the defendant respondent, Your Honor. On the eastern portion of the portion under possession of Mujibur Rahman under holding number so and so some type house is situated. Muhammad Mujibur Rahman has been possessing the portion for more than 20 years, and with the entrance situated on the southern side of the portion, land under possession of Muhammad Mujibur Rahman comes to 2 Katha 7 lachas, Your Honor, including 95.65 meter covering the building, and the same is bounded. So, Lordship, here this 2 Katha 7 lachas is the land of the appellant plaintiff, Your Honor. And Atikur Rahman got your land, which is measuring 3 kathas, Your Honor, which is described. The land of the appellant plaintiff is described in the plaintiff, Your Honor, is Schedule A, and the land of the defendant respondent is described in the Schedule B, Your Honor. And there is a separate boundary between the A and B schedule lines, Your Lordship. Then, Your Honor, may be pleased to come to the plaint, Your Honor. Plaint is to the
FAO has already been admitted.
FO has been admitted. This IA is pending for injunction. Because, Lordship, the only dispute is this, Lordship. Dispute is in respect of the Schedule D of the plane, which is measuring 18 feet by 41 feet. The plaintiff claiming that it is a part of the Schedule A land, and the defendant say that no, it is a part of the Schedule B land, that is the share of Atikur Rahman respondent here. That is the only dispute. So if that is the dispute, Your Lordship, that could have been easily, there is a prayer in the plaint for the appointment of the Amin Commissioner for the measurement of the land of A schedule and B schedule. That was never done by the learned trial court and gave the absurd finding, Lordship, in the impugned judgment, Your Lordship. Your Lordship, be pleased to peruse the impugn how the order has been passed without discussing the
Without discussing?
Yes, page 91. Though the Schedule D is clearly mentioned in the plaint, Your Lordship, which is the suit land, the learned trial court comes to a conclusion that Schedule D is not described. Lordship, the page judgment starts from page 1, annexure 7, 91 of the how, Lord? 91. Lordship, may we please to come to come to page 95, Lordship. From the line 3 from the bottom. It is stated that late Mazahar Hussain, father of the Mafizur Rahman, was the original owner of the land measuring 1 bigha 4 kata 9 lakhs covered by KP Patan number so and so, Dag number. Subsequently, as per the family settle.
Page number 95.
Page 95.
Paragraph number 8.
Yes, Lord. Para,
Eight.
para 7, Lord.
7.
Para 7. At the headline from the after 3 lines, it is stated that
Yes.
it is stated that that late Mazibur Rahman, father of the Mafizur Rahman, was the original owner of the land measuring 1 bigha 4 kata 9 lakhs covered by Dag number so and so, Patan number. Subsequently, in terms of family settlement dated 21/6/25, the OP become the absolute owner of the land measuring 3 kata 5.5 lakhs. That is defended lordship, covered by Dag Patan number same lordship, Dag, which includes the schedule D land, and the father of the petitioner become the owner of the land measuring 6.29, that is 2 kata 7 lakhs, is the schedule A land of the appellant plaintiff. The OP also claimed to be the absolute owner of the ground floor of the 3-story building in terms of the family settlement deed dated 21/6/2000, and that these facts are known to the petitioner as well as the mother of the petitioner and his deceased father, and despite having knowledge of it, the petitioner filed the suit to harass the OP financially and mentally. Then your lordship may we come to the next page, 96. Para 9, lordship. It is stated that, page 96. It is stated that the OP initially tried to start construction over the suit land. The lordship got it. So in the year 2020, but the father of the petitioner filed a writ petition being WPC number before the Honorable Guwahati High Court, and the High Court by order dated so and so allowed the interim prayer of the petitioner father by directing the OP to stop construction over the land measuring 3 and kata 5.5 lakhs. However, the High Court, while allowing the interim order of the petitioner father, directed that both that directed him furnish security of rupees 20, so that in the event of the writ petition it is rejected, the petitioner's father would have required to pay and money as compensation to the OP. Thereafter, the father of the petitioner withdrew the writ petition as there was no merit in it all, and feared that he would have to pay rupees 20 lakh as compensation to the OP in the event of dismissal of the writ petition. It is stated that after dismissal of the writ petition, the OP obtained loan from bank for the purpose of carrying out construction on the land. It is further stated that the vacant land on the northern side of the 3-story building, which is described in Schedule D of the plaint. This is to be noted here, Lord. The court himself come to close the Schedule D is described, but in fact, the land of the OP number OP and the construction activities carried out over the suit land is in terms of the building permit issued by the GMC, and suit land is under absolute ownership. Denying the allegation, the OP demolished the RCC boundary wall on 15/10/20. The OP states that that he will still in wall is still intact and existing, and hence prayer of the injunction petition be rejected. Then your lordship may come to the para 12. From the pleadings as well as materials on record, it is seen that the petitioner inter alia sought for declaration of right title interest over the Schedule A land measuring 2 kata 7 lasa, along with the first and the second floor of the three-storied standing thereon, excluding the carpet area of the ground floor of the RCC building measuring 970 square feet, and the for recovery of the possession of Schedule D land, which is the suit land, Lordship, which is the suit land. According to the petitioner, the suit land is vacant and measuring 18 feet into 41 feet and is part of the Schedule A land. On the contrary, the OP has claimed ownership of the Schedule D land by virtue of the settlement deed dated 21/6/2000. Both parties have relied upon the sale deed to prove their claim on perusal of the said deed. It is seen that the father of the petitioner got share of 2 kata 7 acre land covered by dag number so and so, pata number so, along with the first floor and second floor of the RCC building standing thereon by virtue of a will executed by the father in his favor, that is the Schedule A land. And the OP got his share of 3 kata 5 acres of the land covered by dag number 359 of KP Pata number 230. Apart from the ground floor of the RCC building, by virtue of settlement deed dated 21/6/2005, the Schedule B land. Without entering into para 13 Lordship, without entering into the merits of the suit, it is seen that the allegation of the petitioner against the OP that the OP demolished the boundary wall and they dispossessed the petitioner from the suit land and started erecting RCC building on it. As per the petitioner, the Schedule A and B land is divided by a boundary wall. The petitioner produces photographs in support of the allegations. The OP denies such an act and produces photographs showing existence of the boundary wall. The photographs of both the sides do not show demolition of any wall. It is pertinent to mention herein that the petitioner averred that the suit land is a vacant land, and in part of the Schedule A land, while describing the Schedule land, there is no mention of the suit land measuring 18 feet into 41 feet. This is the large perversity, Lordship, because in the, if you, let me complete, Lordship, then your Lordship may come to page 99, para 14. Para 14. It is seen that as averred by the petitioner himself, the suit land is on the northern side of the three-storied RCC building and the Schedule A land, whereas the boundary of the Schedule land shows land of the OP on the northern side of the Schedule A land. It is also seen that while describing the Schedule A land, there is no mention about the vacant land measuring 18 feet into 14 feet. Absolutely perverse finding. It is the suit land as part of the Schedule A land. The petitioner is not in a possession of the suit land. In such a scenario, in my humble consideration, the petitioner has failed to establish a prima facie case in his favor. Needless to say that the other two principles are not in favor of the petitioner. Then, Lordship, my interim order, which was granted earlier, vacated. Lordship, whenever an injunction petition is decided, Lordship, three golden principles must be discussed: the prima facie case, competing balance of convenience, and irreparable authority. The learned trial court gave the finding that the two other golden principles there is no need to discuss. Now, your Lordship, may please do in the WS file by the respondent defendant.
Tell me if no prima facie case is there. Even if the other two principles are established, whether the court can grant the injunction.
No, Lordship, what I have submitted, Lordship, the learned trial court discussed only prima facie case, and on that basis the injunction was vacated. Other two principles, Your Honor, Lordship, irreparable loss and competing balance of convenience, Lordship, was not touched at all. Apart from that, Your Lordship, the schedule really suit land, Your Honor.
No, Mr. Doe, you come to the last sentence. Needless to say that the other two principles are not in favor of the people.
Not in favor, but how? It is to be discussed, no, Lordship, the competing balance of convenience. how that is not in favor of the petitioner. Then the irreparable loss and injury, lordship. As because the learned trial court passed the impugned order, lordship, without going through the amendments made in the WS and the pleadings. Lordship, be pleased to peruse the facts where the defendant has himself admitted in his WS that the schedule D is the suit line, Your Honor. Just your lordship may please to come to take up the WS.
In WS, defendant may admit it, but you have to establish your case. You
Pardon
cannot
me, Lord?
depend upon the case of the defendant.
Huh? I have not understood lordship, what you have.
You see, you have to establish your own case.
Yes, Lord.
You cannot depend upon the strength or weakness.
Weakness of the defense. That is correct. That is well settled.
Yes.
That is well settled. Lord. My humble submission is this, lordship. Your lordship will please to come to the take up the WS. Where defendant himself has admitted in WS. Para 9, lordship, of the WS. WS আছে ইয়াতে? Good. Page 42. Of the foul.
Yes.
Para 9, your lordship may please to come to page 44. Last para 9. That with regard to the statements made in paragraph 4 of the plaintiff in the answering defendant begs to deny this, and deponent states that in terms of the agreement for family settlement dated 21/6 to the father of the plaintiff become the owner of the plot of land measuring 6.29 r, that is 2 kata 7 which is Schedule A line lots, covered by the number source. The name of the plaintiff father was mutated in the revenue record by the order dated so and so and so and so. Then your lordship may come to the middle portion. The deponent further, middle portion, lordship. The deponent further states that the lordship got it. The deponent further states that in terms of the agreement for family settlement deed dated 21/2, he become the owner of the plot of land measuring 3 kathas 5.5 lacha. That is defendant become. He is admitting there is no dispute regarding the family settlement deed, lordship. A schedule land was given to plaintiff, B schedule was given to the respondent defendant. That the deponent states that the schedule A and schedule B appended to the plaintiff depicting the plot of the land of the plaintiff and the defendant are not correct and hence denied by him, and states that the correct description of the plot of the plaintiff defendant is clearly depicted in the annexure C of the agreement for family settlement deed. So, lordship, what is the correct then boundary? That has been not disclosed by the defendant in the WS. The defendant has admitted that the A schedule belongs to the appellant plaintiff and B schedule to the respondent defendant here. Now, surprising now, in the family settlement deed, your lordship, I'll place later on. The separate boundaries has been shown for the schedule N. Then your lordship may come to the para.
You see, this line that the deponent states that the schedule A and schedule B appended to the plaintiff respectively depicting the plot of land of the plaintiff and the defendant are not correct. Where it has admitted.
No, lordship. Regarding family settlement, lordship, that the 2 katha 7 lakhs as plaintiff got and 3 katha 3.5 lakhs as your honor defendant got. That has been admitted clearly, lordship.
Where? In which part?
Lordship, here. Page 45, lordship. It starts from page 9, para 9, page 44, para 9. That with regard to the statements made in paragraph number 4, the plaintiff, the answering defendant begs to deny this. The deponent states that in terms of the agreement for family settlement dated 21/6/25, the father of the plaintiff become the owner of a plot of land measuring 6.29 r, that is 2 katha 7 lakhs, and covered by the aforesaid dag and pata number. Accordingly, the name of the plaintiff father was mutated in revenue records by order dated so and so of the. However, in the operative part of the said order dated itna, the mutation was erroneously shown to be done on the basis of a sale deed instead of the agreement for family settlement deed, which was also subsequently recorded in the Jamava. Accordingly, the defendant applied for correction of the said mistake before the concerned revenue authorities, and such correction was allowed by an order dated 1912. And consequently, the Jamavandi was corrected in terms thereof. The deponent further states that in terms of the agreement for family settlement dated 21, he become the owner of the plot of land measuring 3 katha 5 and highly covered by dag number so and so. So that is not a disputed fact, Lordship. Schedule A belongs to the plaintiff. I prayed for injunction over Schedule A, part of the Schedule A, that is suit land is D, not over the Schedule land B, Lordship. That vital aspect was not considered by the landed trial court, Lordship. Then, Lordship, be pleased to where the existence of the D schedule has been also admitted by the defendant by para 17 of the WS Lordship. Whereas the learned trial court gave the finding, there is no description of the schedule D in the plain. Lordship, be pleased to come to page 51 of the file, para 17 of the WS. That with regard to the statements made in paragraph number 18 of the plaint, the answering deponent begs to deny the same. The deponent states the vacant land on the northern side of the 3-story RCC building, that is the suit land, which is described in Schedule D of the plaint, is in fact the land of the defendant. Herein, in terms of the agreement family settlement deed dated 21/6/2005. So, Lordship, when the defendant himself is saying that there is a Schedule D suit land, Your Honor, but he says that this suit land was allotted as per the family settlement to the defendant, not to the plaintiff. Absolutely false averments have been made on oath, because Your Lordship may be pleased to the family settlement drawings, Your Honor. It is in Iowa, Your Honor, which shows the complete separate boundary between the Schedule A and B and suit land D, that Your Lordship will find. Drawing page 73 of the IA, Lordship.
Yes.
This is the drawing, Your Lordship, which was along with the family settlement deed, Lordship, and this has been annexed by the defendant himself. Your Lordship will see that here, your Schedule D, Your Lordship, where Your Lordship, on the right side, RCC building has been shown. It is a 3-story building. First and second floor belongs to the plaintiff, ground floor belongs to the defendant, Lordship. And this is in the just a rectangular plot is there, Lordship, which is Schedule D, suit land. And here there is a clear, Your Lordship, where the RCC is written just bottom, Your Lordship, find a rectangular map. That is suit land, Schedule D, Lordship. And thereafter, beneath that, there is a partition showing between the Schedule A and Schedule B. Schedule B, which clearly shows that the suit land Schedule D is a part of the Schedule A. Suppose, Your Lordship, the defendant has averred that Schedule D land, suit land belongs to the defendant, not to the plaintiff. So that could have been easily decided by measurement through the Commissioner, Lordship. Until then, it was the duty of the learned trial court to grant the status quo, directing both the parties to maintain a status quo, Lordship. And as because the father has this appellant, Your Honor, just is 20 years old. His mother is widow. So taking the muscle power, he has occupied the schedule, defendant has occupied the schedule suit land. And the finding, Lordship, when Lordship will be pleased to come to the plaint, because the learned trial court has came to the finding that no Schedule D has been plaint, Your Lordship will found in the file, that is page 13. Lordship may come to page Lordship 32 of the file. Page 32, Your Lordship. Oh. Lordship, Schedule A, that is the land of the plaintiff. Now, Your Lordship, the Schedule B, the land of the respondent defendant. Schedule C is a separate holding, Your Honor. Then Schedule D is the suit line, Lordship, measuring 18 feet by 41 feet. And the learned trial court has given the finding that there is no description of the Schedule C D line. Last part of the impugned order, Lordship. Lordship, may be pleased to come to page 98 of the how, where the 99, Lordship. Page 91, para 14. Lordship got it?
Page 99 paragraph.
Paragraph last, page 14.
Yes.
It is seen that as averred by the petitioner himself, the suit land is on the northern side of the three-story RCC building and the Schedule A land, whereas the boundary of the Schedule A land shows land of the OP on the northern side of the Schedule A land. It is also seen that while describing the Schedule A land, there is no mention about the vacant land measuring 18 feet into 14 feet, that is the suit land, as part of the Schedule A land. The petitioner is not in a possession of the suit land. Because in such a scenario, in my considered opinion, the petitioner has failed to establish a prima facie case in his favor. Needless to say, the other two principles are not in favor of the petitioner, Lord. The learned trial court gave the finding that the petitioner plaintiff has not shown that the Schedule D suit land is a part of the Schedule A land, Lordship. Whereas, Lordship, in the plaint, it is clearly shown. It starts from page 13 of the file, Lordship. Lordship will see again. Schedule starts from page 21 of the file. Schedule A, Schedule B, Schedule D. Now, Your Lordship, I am placing Schedule D. Page 22, Lord. All that a parcel of the Schedule A land on the northern side of the three-story RCC building of the land measuring 18 feet into 41, which is a part of the Schedule land. In the learned trial court gave the finding that Schedule suit land is not mentioned, not described. And Lordship,
Okay.
Lordship, one thing I'd like to please. Your Lordship, be pleased to come to page 26 of the IO. That is the family settlement deed. The learned trial court gave the finding that boundary is not correctly depicted. And the family settlement deed shows the actual position, Lordship. Page 26, which has been admitted by the respondent defendant. He has not denied it. IA, Lordship, page 26. Your middle portion of the para A, Lordship. Mujibur Rahman has been possessing the first floor and second floor. Mujibur Rahman was the father of the appellant, Lordship. Constructed by first party himself along with the some type house holding number so and so, standing in the name of second party, the staircase leading to the first party and second floor. Building is situated on the western side of the building, leaving the entry to the ground floor of the said building, which fall in the share of Atikur Rahman, that is the respondent defendant. On the eastern side of the portion under possession of Mujibur Rahman, that is the father of the plaintiff, Your Honor. Under holding number so and so, has been possessing the portion more than 20 years, and the interest situated on the southern side of the portion, land under possession of Mujibur Rahman, father of the plaintiff, comes to 2 kata 7 lesser, including 95.65 square meter, covering the building, and same is bounded by, Your Honor. This is very important. North land of Atikur Rahman, that is land of the respondent defendant. South KKB Road, East private road is by, but this family settlement deed, Your Honor, and lordship may come to page 27. Page 27. The boundary of the defendant respondent also is shown in the family settlement deed. C, clause C. Muhammad Atikur Rahman, that is defendant respondent, has been possessing share of the land measuring 3 kata 5 LH of the land, including ground floor of the 3-story building under holding number 27A, has the houses under holding number 29, and a vacant plot of land measuring 1 kata 5 plus that, and his portion is bounded by north drain, south portion of the land of Mujibur Rahman, that is appellant defendant, Your Honor. East private road used by Atikur Rahman and Rejibur Rahman. Rejibur Rahman is the one of the brother of Atikur Rahman. West land of the Roman Taluk. This boundary was never challenged. Rather, the respondent defendant has admitted all the contents or clauses of the family arrangement deed lordship. So my humble submission is this, Your Honor. Only dispute is whether the Schedule D suit land is a part of the Schedule A land or Schedule B land. So best course would have been on the part of the learned trial court to maintain the status quo, appoint the Amin commissioner, and if the D schedule is found in the position of the defendant, Your Honor, or part of the B schedule land, we will not object. But actually, in fact, Your Honor, this Your Lordship has gone through the map, which was annexed with the family settlement deed. This D schedule suit land is a part of the A schedule land. So, and in the I would like to relax.
Yes.
High Court. On judgment, I would like to plead.
On which point?
On the which point, Lordship, that injunction.
No, in that the established then just for the
Lordship, if the injunction is not granted, the entire suit will be infructuous, Your Honor. And in the meantime, what happened when the injunction order was vacated? On the third day, the roof has been, ground floor roof has been casted over the suit land by the respondent defendant. Your Lordship, yes, casted lot. Because mother is widow, father has expired, and he is just 20 years old. Appellant lot. These photographs were taken after vacating the injunction order by the learned trial.
yes.
So my humble submission is this, Your Lordship. For the ends of justice, Your Lordship, I would like to place on our High Court judgment. Citation here. Citation is Lordship. Print there. Print para Lordship. Para 12. This is 1981 1 JLR page 231. This is a leading judgment para 12 division bench law. Para 12 from 1, 2, 3, 4, 5, 6, 7. Line 9. Where is the soul?
Only 4 pages. There are 7 pages.
Sorry, sir. It is mistake. Para 12. The circumstances under which temporary highlighted portion you will optimize, please to it. This so
Okay, no need to read it out. I will go through it.
okay.
Yes.
So my humble submission, Lordship, the learned trial court completely misconstrued the facts, Lordship, and the finding given by the Schedule D is not described in the plain. That is an abstract, perverse finding, Lordship. So my humble submission is, Lordship, both IA may be disposed of and even appeal may be disposed of, Lordship, by directing both the parties to maintain the status quo in respect of the schedule should delay. That is my humble plea.
Okay.
Kindly come to page number 71 of the IA. Page number 71 of the IA, they have filed. This is the computerized plan that the plaintiff had submitted before the learned trial court. This is the plan as per them. This is the schedule that we have denied. Lordship has already seen.
Not
And-
denied. They have claimed that Schedule D belongs to the respondent defendant.
Let me
That
submit
is,
or let. You can reply.
You are good.
Page number 71, your Lordship. Kindly to them. This schedule A, B, C, and D. This is as per them they have projected before the learned trial court. Now, this is the registered annexure C to the registered deed is at page 73. They have annexed here. But before the learned trial court, they have not annexed. This is the site plan as per the family agreement. Now, your Lordship sees, compares the both. This schedule A that they have given is a rectangle, Lordship. Page 71, schedule A, they are saying, they are claiming the entire portion. But if in the family agreement, page 73, your Lordship will see, the property of the plaintiff is only the A portion. Here A is mentioned. I'll give a clear copy here. Lordship, here it is not clear. This is a clear copy. This is a registered document. This is a part of the family agreement. Now, this portion is A. The right hand
Is
side.
there any difference between page number 7, 53 and this page?
Page 71.
No, 73.
And no difference at all.
No.
No difference. Only here it is registered. This is not the unregistered page, but it's an exact copy. It's an exact copy. 73 and this one. Here in the page number 73, your Lordship will find the seal of the senior sub register. Here it is not there. It's a copy, but it's an exact copy. Lordship, page A, if your Lordship, this A, if your Lordship sees 2 kotha 7 lesser, this is the portion of the father of the plaintiff. Now, my portion, your Lordship, comes to 3 kotha 15.5 lesser as per the family agreement. That already my learned senior has placed, I will also place. My portion, your Lordship will see B, C, and D. As per this B, C, and D, if we add 10 lessers, 1 kotha 5 lessers, and 1 kotha 10.5 lesser, it comes to 3 kotha 15.5 lesser. So this 10 lessers, your Lordship, this B, in the page number 71, they have included this 10 lesser portion. Page number 71 that they had projected before the learned trial court, they have included this. This 10 lesser portion they have included in the schedule. That's why we have denied, you know. Otherwise, the share as per the family agreement, Lordship may kindly take up my written objection. I will place the relevant clauses. Once again, your Lordship, page 135. Your Lordship comes for a moment, page 135, A. Your Lordship, along with the map, Lordship will find the more of page 135.
Clause A, Mujibur Rahman has been possessing the first floor and second floor of the RCC building constructed by the first party himself along with one Assam type house.
135.
Lordship, page number 135, clause A. This is the agreement, family agreement, registered family agreement. Mujibur Rahman, that is the father of the plaintiff, has been possessing the first floor and second floor of the RCC building constructed by the first party himself, along with one Assam type house under holding number 28, standing in the name of the second party. The staircases leading to first floor and the second floor of the RCC building is situated on the western side of the building, leaving the entry to the ground floor of the said building which fall in the share of Muhammad Atikur Rahman. So my ground floor entrance is from the eastern side, Your Lordship. In my objection also I have annexed the map at page 142. At page 142. This is also not a very fair copy. I have given the fair copy to Your Lordship. This from the B portion, I enter. There is a bylane from the KKB road. Your Lordship, please. KKB road. From the private bylane, I enter from the back portion B, the stainless plot. From here, is my entrance to the building. And his is from the south. That is from the KK Bhatta road. On the first plot is his plaintiff. So now, if Your Lordship come back to the clause A, page 135. On the eastern side of the portion under possession of Muhammad Mujibur Rahman under holding number 28, the Assam type house is situated. Muhammad Mujibur Rahman has been possessing his portion for more than 20 years with the entrance situated on the southern side of his portion, that is on the KKB road side. Land under possession of Muhammad Mujibur Rahman comes to 2 kotha 7 lesas, including 95.65 square meter, covering the building, and the same is bounded by north land of Atikur Rahman. That is me, Your Lord. I am the defendant. So on the north side of the building is land of Atikur Rahman. Clearly it is stated. On the north, my land starts. And clause C fully describes my portion of land. Muhammad Atikur Rahman, down below, Your Lordship, last two lines. Muhammad Atikur Rahman has been possessing his share of land measuring 3 kotha 5.5 lesas of land, including the ground floor. So ground floor of the 3-storied building under holding number 27A, attached houses under holding number 29, and a vacant plot of land measuring 1 kotha 5 lesas, and his portion is bounded by north drain, south. On my south is portion of land of Mujibur Rahman, that is father of the plaintiff. East private road used by Muhammad Atikur Rahman and Muhammad Rajibur Rahman, the private road that I have shown in the map. West drain and land of Mr. Robin Talukdar. The entrance to this plot of land is situated on the eastern side of the said plot. A site plan prepared by the first party is annexed with this deed as Annexure C, that I have placed, Your Lordship, the site plan. Now, Your Lordship, earlier also, they have filed a litigation before this Honorable Court. To the pleadings of that case, I want to bring to the notice of this Honorable Court. Lordship may kindly come to page 150, my objection. Annexure 5 is the writ petition. Now, in the earlier round of litigation, what the father of the plaintiff has pleaded, Your Lordship. It's a short writ petition, otherwise I would have read the whole pleadings, but due to paucity of time, only paragraph 7, Your Lordship, I will please. That the private respondent number 5 is the owner of the land measuring 3 kotha 5.5 lesas, over which the respondent number 5 had started construction of the RCC building with effect from first week of December 2019. Clearly admitted here, Your Lordship, father of the plaintiff, that over my plot of land I have started construction in the first week of December 2019.
So the land is not under his possession.
Not possession, and it's my share of property as per the agreement also. And father of the plaintiff has also clearly admitted in the writ petition in the earlier round of litigation.
Lordship, in 24, when the respondent has started construction without taking building permission from the GMC, on that ground, I have lodged the complaint and filed the writ petition, Lord. And only they had obtained the NOC, Lordship, in 22.
This is in 2010. Let me submit. Paragraph 7, Your Lordship will kindly see. This is the only allegation that without leaving that the private respondent number 5 is the owner of the land measuring 3 kotha 5.5 lesa, over which the respondent number 5 has started construction of the RCC building with effect from first week of December 2019 without leaving any side margins by touching the RCC building of the petitioner and without obtaining any NOC from the GMD/GMC, and as such the construction started by the respondent number 5 is illegal and unauthorized, which is liable to be demolished. This was his case, your lordship. Now, your lordship will come. They have also given a schedule in the writ petition, page 156. Schedule A and Schedule B. This is the same as in the plain, you know, same plot of land. They are harassing me since the year 2020 that I should not build this building. You know. Now, page, when this matter was, page 156, your lordship has seen, Schedule A and Schedule B, same schedule as in the plaint, your lordship will place plaint from there. Plaint, if your lordship is page 21 of his FAO, page 21 of his FAO, Schedule A, land and building of the plaintiff. Here he has stated Schedule land and building of the petitioner. All that a plot of measuring 6.29 hours, that is 2 kotha 7 lesses, covered by KP Patta number 230, being part of DAG number 359. And Schedule B, land of the respondent number 5, that is the defendant in the plain, 3 kotha 5.5 lessa, covered by same DAG number. Regarding the same earlier round of litigation, father has clearly admitted that I have constructed in my plot of land, and I am in possession, your lordship, in terms of the family agreement. That is a settled position. So prima facie, your lordship, and this honorable court, on of the matter, at page 165, there is an order. This writ petition was taken up for hearing. What this honorable court has observed. This is on the first day. So I'll not read the entire order, only the operative part, page 166. Page 166. As an interim measure, the concerned official of the respondent number 1 to 4 shall issue necessary direction to the respondent number 5 to stop any further construction on the plot of land measuring 3 kotha 5.5 lesa, covered by KP Patta number 230, being part of DAG number 359 of village Sohor Guwahati, 7 part, Moza Ulubari, till the next date of listing, that is 3/6/2020. The petitioner in the meanwhile is directed to furnish security to the extent of rupees 20 lakhs to the satisfaction of the registry, so that if the writ petition is disallowed, adequate compensation may be paid to the respondent number 5 for the delay in the proposed construction. As ex parte interim order is passed against respondent number 5, liberty is granted to the respondent number 5 to apply before the court for modification of the order in the event he has the requisite construction permission from the competent authority. Now, subsequently, page 167, your lordship, this is the final order, page 168. They have withdrawn the writ petition, your lordship. Ms. S. does learned counsel appearing for the writ petitioner submits that she has instruction from her client to withdraw this writ petition. Also heard so and so learned standing counsel GMC appearing for respondent number 1 to 4 and so who do not have any objection if this prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal. Interim order passed earlier shall stand vacated. Now, after that, your lordship, I have annexed the photos of the site, your lordship, page 169 and 170 in next page itself. The walls are intact, your lordship. Even in their photos also, walls are intact. Their allegation that I have entered into the property by breaking the wall is completely false, your lordship. Walls are intact, and these pillars are of 2019 when they had filed it, 2020. And page 170 I have annexed. Because of their leakage from their drainage pipes, there is damage to my house. So in that view, I had lodged a complaint, your lordship. Annexure 9 I have annexed the pipes, how they have placed in above my entrance door also they have placed a pipe, bathroom sewage pipe, your lordship. And because from the leakage, my walls have cracked, the internal walls where I'm residing, it has become unhygienic. Foul smell comes throughout the day. And accordingly, I filed a complaint, Your Lordship. Next page, page 171, to the Commissioner, Guwahati Municipal Corporation, 18/10/2024. This is received copy. With due regard, I beg to state that my adjacent land, first and second floor building owner, namely late Mujibur Rahman, was constructed unauthorized toilet on my land without my permission from me or any government authority, and due to which I am unable to construct my new building. The new building permission was granted by the Guwahati Municipal Corporation to me to construct the building. I took financial support to construct the building from the Punjab National Bank. Due to leakage of the pipe, the excrement water has come out, including the bad smell, and for the leakage of the water, the ground floor of the building damaging day by day, and I am also unable to stay in the room due to bad smell. I orally told them to demolish the illegal toilet pipe, but till that they have not demolished the same. It is therefore requested that Your Honor may be pleased to demolish the illegal pipe constructed on my land. As soon as I lodged this complaint, Your Lordship, they filed the title disputing, creating this all drama. And I have annexed my loan sanction certificate at 172. I have in their IA, Your Lordship, they have annexed my land building permission. Before that, Your Lordship, may I kindly take up page 74 of the IA. I have not annexed in my objection, but this is my land building permission. Your Lordship. At page 74 of the IA. It's in the IA. This is from the Guwahati Municipal Corporation, page 74, Your Lordship. Annexure 15. This is the building permit dated 2/6/2022 to Atikur Rahman. That is the no objection certificate for construction. Your application dated 11/8/2020 and planning permit number so and so. With reference to your above application for permission to erect a building structure at house number so and so, it is hereby accorded, and you are required to comply with the conditions mentioned overly in accordance with plans submitted with modification. The particulars of the construction for which permit and accordance is given below. This is residential type RCC. Tag number, patta number is mentioned, word number is mentioned, and my drawing is also annexed at page 77, annexure 16. This is the extension that I have got permission from the GMC, Your Lordship. And against this permission, Your Lordship, I have obtained the loan from the Punjab National Bank.
Lordship, one thing I like to clear, Lordship, my learned friend has submitted that earlier a writ petition was filed. That writ petition was filed in 2020, Lordship. And when the respondent defendant had started construction over his land measuring 3 kata 5.5 acres, B schedule land. I filed the writ petition only on the ground that he has not obtained building permission and he is not leaving the size margin. So ultimately, the building construction work was stopped, and he obtained the defendant obtained the NOC from the GMC in 2022. That is not disputed. And showing therein in the building plan, Lordship, as if the 3-story RCC building belongs to the respondent defendant, Lordship. I have taken all these plea, Lordship, and without leaving any side margin, Lordship, he has casted the roof of the ground floor over the suit land, that is D land. Now, my learned friend had placed the settlement map, Lordship, which was as per the family settlement deed. In the IO, I will show the distance between. Lordship, my learned friend had submitted that.
No, not necessary. We are testing the order of detection of your injunction. Not necessary. Point out all those things. We'll pass the order. Next slide.
May I please, Your Lordship?
Yes.
In this continuation petition, Lordship, there is a 5 days delay.
Delay of 5 days.
5 days, Lordship. Delay caused because of my sickness, Your Lordship. That's appellant. Applicant has no fault on that, Your Lordship. And Your Lordship has discretion to condone the delay, Your Lordship.
That's all right, but
Because of my sickness, I could not file it in time.
that's all right, but let notice go at least 6 days.
Only 5 days delay, Lordship.
Maybe
You, Lordship
the other side
Lordship
go.
can condone it, Lordship.
Let notice go.
So we may be
At
allowed
the
to,
time of hearing, definitely we will take into account your submission.
Lordship.
Third, applicant. It's application under section 5 of the Act for of 5 for regular second appeal against the judgment and decree
Dated, Lordship, 4 March, 4th of March
2025.
25. Entitled appeal number 2/21.
Let notice be issued to the respondent returnable in can you take the third by Dustin?
Dusty, Lordship, we'll try our best, Lordship.
Then we will fix it after 2 weeks.
Lordship.
Returnable in 2 weeks, step be taken by registered both AD and also by the process. Justice service is also permitted after effective terms upon the response for the application shall file an affidavit. This after 2 weeks. After 2 weeks.
31.
Oblige, Lordship.
May I please be me, Lord? Lordship,
Yes.
this is condonation delay petition, first time, Lordship, so notice may kindly be issued, Lordship.
89 days.
89 days, Lordship, then are similar matters also there, 34, 37 and 39. 34, 37 and 39, Lordship, if Lordship permits. There will be similar, but days are different, Lordship.
Okay.
In 34, 124 days.
Okay, we will issue notice.
Okay, much obliged.
But matter may be passed over for the time being. Senior on legs, Lordship.
It's I for what purpose?
Delay condonation.
How many days?
87 days, Lordship.
Let notice. Your good name?
Amen.
Okay. Returnable after 4 weeks.
Delay first time 788 days.
7?
788.
Let notice.
Hello, bless.
Right, please, your lordship. There is a delay of 8 days filing RFA
8 days.
only.
Okay. Let notice go. After 4 weeks.
I will.
My lord, delay of 108 days.
Okay.
May I please, Your Honor? My lord, in this case, my lord, 47 days delay, my lord.
47 days.
Yes, my lord.
Not
Most obliged.
Appeal option. This is an application for continuation of delay.
Pardon?
This is an application for continuation of delay of 86 days in filing appeal.
okay. Notice. 4 weeks.
Step in both ways. Nothing.
42.
Yes.
75-day delay, my lord, in the condonation petition in filing the RFA.
Okay, let notice go ahead.
Obligement.
I am appearing for Lordship 7, 8, 9, and 10.
8, 9, 10, 10.
Yes, sir.
8,
8, 9, and 10. Huh? So I'll
one
give a
more
copy. I'll give her copy, my lord.
Okay.
8, 9, and 10.
Okay.
It's an application for condonation of delay.
How many?
115 days.
Notice.
Obliged. Obliged.
Wait, please, Lord. Lordship, in this case, we have instruction that already petitioner died, Lordship. Your Lordship may close this if they came later on, then we can file substitution, Lordship.
Now we can close it.
Yes, Lordship. He was a mutawalli, Lordship. Accordingly, an order was.
Heard, petitioner, non-appeals could have responded. That the petitioner died.
Yes, Lordship. I have telephonic instruction that petitioner died.
For her property. Well,
Lordship, that I could not obtain.
property as the matter may be closed. Accordingly, taking close.
With liberty to file any substitution application if they came later on, Lordship. Lordship, this petition may be closed with liberty to file substitution application if later on they came, Lordship. They can satisfy the court, Lord.
Having closed the petition, grant you liberty.
As because, Lordship, the close as abated, at least that much, Lord. On the death of petitioner, so the petition has been closed as abated, Lord. Problem.
Service report is awaited. Service report is awaited.
There were some specific direction given to the appellant to take step upon the respondent number 1, Lordship.
As per office note dated, my lord, 22/7/25, and office note dated 31/7/25. Which step was taken?
2/6 because there is a direction 2/6 taking into account the above, the appellant is directed to effect service upon the respondent number 1 after ascertaining the proper address within 16/6/2025. There is a court's order, Lord.
Accordingly, I have taken. My lord.
Heard, sir?
Here.
Heard it for the appellant, for the respondent number
2, Lordship.
respondent number
2 and 3, Lordship.
2 and 3.
Yes, Lord.
Dated 37/5/6. Notice to the respondent number 150 on 13/7/20. This is the matter after 2 weeks, everything service put up for one.
Obliged.
Please, Lord. So can the matter may be taken up on Wednesday, Lord? My senior, Wednesday. So my senior, Mr. K. Singh, had to leave due to some family emergency, Lord.
Where?
Due to some family emergency, Lord. Initially, Mr. K. Mohanto was supposed to do the matter, but he is not well, and we have given a letter of leave of absence also. After that, Mr. K. Singh was doing the matter, Lord. He had to leave. Lord.
As read for by Mr.
As Gautam, your Lordship.
As Gautam, learned counsel, the fabric objected by learned opposite party number
5.
5.
I mean, all
opposite party,
all the opposite parties.
Wednesday.
Please.
What? 19. Oblige, Lord.